watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.
Welcome to the Florida Supreme Court. Our first case for the day is amendments to the Florida Rule of Judicial Administration. You may proceed.
May it please the Court. My name is Keith Park. I'm from West Palm Beach. I'm here on behalf of the Rules of Judicial Administration Committee, and we're all here today regarding 2.420, which we've looked upon as type of a glitch bill, if you will. One of the things I wanted to point out to the Court with respect to this is that this was more than just an RJA effort. We really had a work group, even though it wasn't planned that way. What we found is that we needed information from a lot of sources, most of all clerks, and probably a little bit more from the criminal side of the practice. So all of those things plugged into it, so I just wanted to let the Court know that this wasn't just RJA that did this. I think the part of the whole thing that's a little bit important is most of what we did grew out of the attempt, I think, to educate the bar and educate the clerks. And Mr. Regensdorf and Judge Krieger did some fine CLE work, and I think they got a lot of feedback from the clerks and from the lawyers, which caused us more questions and made us do a lot more work. But I think that's really kind of what put us where we are. We found out what was wrong with the rule and what needed to be fixed. I'm not sure we're done by any means. This is maybe you'd call this rule a beast. This is a very complex rule, and it's probably a work in progress.
Just a question on that, because this has been in progress for so many years. Is there any other way that you can envision dealing with this continued issue? I know we're going to see it. We have it with e-service, e-filing, and then this rule. They all kind of work together to make sure that we ensure access electronically to records, but protect those that are either exempt or under legislative requirements. So have you thought, maybe we just need to do this outside the oral argument, but I just can't imagine every 6 months or year for the next 5 years having to have the process go this way, as opposed to something that maybe is a bit more informal for these three rules. So it's just something to think about. I know Mr. Regensdorf, I'm sure, has views on that, and maybe we can address
from this side of the podium. Yes, ma'am. That's really what we need to do, and what we're going to find out, I think, over the next several months, including after when e-filing cranks up, that we're going to have a lot more information. Right now, I'm working on 2.516, which, although the immediate clamor didn't come back, now we're getting a lot of feedback. In fact, I noticed in this rule there's a change in one of the subdivisions that refers to 1.080, and that'll need to be changed to 2.516.
So, I mean, that kind of thing, to think about having a petition filed and go through all of that, seems that maybe we can just come up with a more streamlined process. Certainly your committee would.
We would all be in favor of that, yes, ma'am. I can't imagine that. And I think the court would appreciate that kind of endeavor as well. It's a little bit difficult to go through the petition process, and right now we're working on the joint petition to try and work with 2.516 and everything that's generated. And the court has already entered at least one rule or one order that I'm aware of on August 30th, trying to clarify that, and we're going to try and work on that some more. And those things kind of plug right into this, don't they, as the court is well aware. And with respect to this, what we were trying to do under the D1B, those 20 items, we got clerk feedback with regard to that. There was some confusion that they thought somehow the rule trumped what was going on in the statute, and that just wasn't the case. So it was incumbent upon us to go back and try and see if we couldn't correct that. Our intent was not to change anything, including subsections 10 and 20 that we're back here on today, that I'm going to kind of let Mr. Regensdorf and Mr. Young talk to the court about that. I just wanted to point out that from the RJA committee side, we were trying to clarify we were not attempting to change, and I don't think we did. The other provisions that came in that I think are pretty clear-cut, at least if the court has any questions about them, but I think principally we had issues with respect to the notice form was a real problem for us, because it was clear from the feedback we were getting that it was the clerks and practitioners were concerned about the fact that the form itself was so explicit that it violated the confidentiality. So we tried, as we would, to come up with as many different solutions, and I can't emphasize the fact how many hours we spent trying to figure that out, and we came up with this short form based principally on the feedback we were getting from the clerks. The clerks were saying, we don't even need a form, okay? We can do this without a form because we know what these things are. And as a matter of fact, the intent was to come up with these 20 things that would be pretty clear to the clerks, but we realized that we couldn't go there. I'm just telling you that from what we were getting back from most of the clerks, I won't say all of them, most of them were saying, we can do this, that we don't need that explicit form.
Well, if they enter an order on something that's they deem to be automatically confidential, on an e-filing order, how does that, do they indicate which subsection then that it's being sealed under, so that if somebody wants to try to unseal it, they know, from the electronic docket what is? Do you understand my question?
Yes, I think from the prospect, it doesn't do that. Okay, but what it does do is that there's a motion or a notice that puts the public and the record on notice about what that document is, and then what's done with that document, I suppose, is the feedback with respect to that answer. That is, then one sees what
well, I'm saying that's why I think the notice is important, because you then have that for somebody who thinks it's wrongly being kept sealed or confidential.
We agree with the court, and for a couple of reasons. Number one, I think it's clear from the way the order or the rule was written by the court that the court expects practitioners to be involved in this process. It isn't it's clearly a clerk's job, although it places the burden on the clerk to do this if it's not done clearly. And that's one of the reasons that we have this after-the-fact redaction that we came back with, that if there is one of these documents and somebody sees that there's something wrong with it, we don't have to go through the motion practice in order to get it removed. We can file a notice, and the clerk can go back and do that. So some of these things are pretty clear-cut on their face. The after-the-fact redaction, how we clarified who a filer was, because some clerks and some judges were concerned that, hey, I'm a filer because I file stuff. And the oral motion came up. That was another area of discussion because we were concerned about making sure that there were enough safeguards in place that this wasn't going to be some secret way of getting something deemed confidential that didn't pass the proper purview of or proper review by the court. So
let me ask you something about subdivision D. There's a lot of change of language in subdivision D, and many of them seem to change what was originally saying identifying information to the actual clinical records. And I'm just because it seems to me that what were said originally is that you're redacting information that identifies who the person is, whereas now it seems to read you're identifying the complete record. Well, is that the intent of what this change in language is, and is it in keeping with the statutory provisions?
The intent of what the change was specifically was to look at the statutory reference, look at what the statute says, try and keep as close as we can to the statute without misleading somebody, still making them understand that they really need to look at the statute, that this isn't the controlling language. But what we found about that was deceptive about that the identifying feature of what that stated was that really wasn't what the statute stated. And we were concerned that because it really had parameters or limitations that were not in the statute, that it improperly set forth what was in the statute.
Okay, and so, for example, the one that said that the language is being changed, it says clinical records of criminal defendants found incompetent to proceed or acquitted by reason of insanity. That the statute actually says that the entire record is confidential as opposed to the information that identifies the defendant. So the entire record versus the identifying information is what's confidential.
I think the best way I can clearly state that, because again, what we're trying to have people do is reference the statute. The statute isn't so limiting as just to have that particular identifying information. It's the only thing that's not. So we wanted to leave it up to the court and up to the practitioner and up to the statute exactly what is deemed to be confidential, and not somehow change what the statute says. Clear enough? I mean, that's exactly what we were trying to do. Okay. Whether we accomplish that, I suppose, is the eye of the beholder. But the impetus here was to make sure that we weren't misstating what's in the statute, and that's what the conclusion was, that it in fact misstated what was there. So that's why the change. And with that, I shall. Anybody on the court has any questions about that? I think I've kind of outlined everything, and not all that. Although the rule may be complex, I think what we did to try and get rid of some of the complexity and make it easier to use from a lot of perspectives. We hope.
Let me ask you one other question. What was the impetus for changing the G2, I believe it is, so that there's a 30-day deadline for determining the confidentiality?
Because it wasn't addressed at all. There was no. If I'm recalling the correct section, that in that particular subdivision, it did not leave a limitation about when that ruling would occur. We felt that was it was something that we felt it was something that was left out that should have been there. There should be some kind of time frame when something occurs.
That runs from the time the motion is filed?
Well, it can either be the time the motion is filed or if there is a response. I think that's the way it's worded. I'd have to go back and look at it. But I recall if somebody responds to that motion, I think that extends the period. Again, to be sure. Thank you. My pleasure.
Please the court. My name is Bob Young. I'm pleased to be here on behalf of the 100 assistant public defenders and tens of thousands of clients, and start with just wandering a minute of my time to thank your rules committee folks, the women and men who work on that process don't get nearly enough credit. As you may have noticed, it's getting harder and harder to craft the rules that fit each other, fit the statutes and the complexities of things, and all those folks deserve a lot of praise from all of us who every day work under your rules and hope that your rules produce efficient and just outcomes for the folks who follow them. And unfortunately, as this one's written, it doesn't do that now. Just because they work hard doesn't mean they always get it right the first time.
Could you just reference the specific rule that you're
Yes, ma'am.
concerned with?
We're here solely on the issue of the confidentiality of psychological evaluations. It's governed by 2.420, and it's
so it's under. Is it one of the ones that's under the whatever that we're just going based on what the legislature has indicated?
Well, I think that's their position.
But I'm asking you, is it within the 20 mandatory?
Yes, ma'am.
Okay, so you understand, I'm sure you do, that what the court was doing there is identifying what the legislature has said is to be confidential.
I understand that was the intent, yes, ma'am. But in doing so, well, let me just start with what we all agree on. I think everyone in this room agrees that the material in these reports it would be terrible public policy to have that public.
And you do understand, and that's what I say, victims of crimes, there are things that are embarrassing.
Oh, worse than embarrassing.
And worse, but the court was trying here to follow the legislative direction as to what records needed to be
exactly
kept and which are not.
That's right.
And we don't have, at least under our interpretation, greater authority on this to make things automatically sealed.
Well, it's exactly that point that I'd like to talk about. I think we all agree that trial judges all over the state can, in any case, seal any record when it fits the 7 items that are in that rule. On a case-by-case, time after time, over and over again, sealing a record. And I think you'll find in practice they do that routinely. And every time a psychological evaluation or psychiatric record is filed, they make the same findings over and over. And they don't need a 2/3 vote of the legislature to do that. And they don't need the 107 votes or whatever it is. And they don't need that because your rule, which was passed before the effective date of the amendment, says that trial judges can do that. The very same language and the very same rule says that a court record can be sealed in a case decision or a court rule when it meets little I through Roman numeral 1 through Roman numeral 7. So if it can be done by the trial judges in a case decision, and if your rule says case decision or court rule, why can't this court, as a matter of categories, say these categories are so pervasive as to be in all of these reports almost all of the time, and by rule, therefore, these reports should be sealed? There are at least 4 that come to mind that I think it's inarguable that those 4 would apply to every every report. And so if the trial judge can look at the report and see that it meets the test, why can't this court look at the category of reports, find that it almost always contains school records, which by public policy and by law are exempt, It almost always contains drug abuse information. It almost always contains psychological evaluations by community-based treatment centers and by school psychologists and by the doctor who's doing the report.
We see this in death cases, and I don't recall ever there being that those reports that are then where they're testified to. Are you saying these are ones where nobody has testified to and they're just being done as part of what's the context?
Well, the context is the doctors who are appointed by the courts and paid by this court to make these findings send these reports to the parties and to the judge. Unfortunately, the judge's copy almost often goes to the clerk and gets stuck in the court file before anyone knows it's there. So when the lawyer is offering that report in evidence, almost always by stipulation, then the original of that is almost always
so if it's being offered in evidence.
That's right.
You're not saying there it's being sealed.
I am saying it's being sealed. It should be sealed right after it's received.
I'm just. Did we not address this issue in a prior rule case and rejected this position?
Absolutely. But I think Mr. Riggensdorf would suggest that, precedential rules, stare decisis, somehow apply to that. My view is the motto that I see here and up there would trump that, and soon enough, if rightly decided, is the best way to do it. And these rules are important to all of us. They're rules we all share. And it seems clear that this court has the power to look at the contents of these things on a categorical basis, determine that as a matter of categories, they almost certainly contain the things that the trial judges find they contain, because they're still sealing them routinely, always. And say that because the trial judge shouldn't have to have a hearing, the lawyer shouldn't have to file the notice of confidentiality, because everyone knows when there's a psychological evaluation there, it has at least a half dozen of those 20 things in it. There's never an objection by the parties that you would normally expect to be opposed in these things. The only objection seems to be whether or not this court has the power to make the categorical decisions that these reports always contain the matters that are in there. There are threats to the orderly administration of justice, there's harm to innocent third persons, there's harm to the defendant itself or to a party, and they're contrary to public policy. When they have medical information in them, and they always do, and when the public policy is that medical records are confidential under federal, state law, as are domestic violence records and sexual abuse records and 1,000
Are you saying all
things.
medical records are subject to being sealed? I mean, in a civil case, when the person's physical examination is at issue, that those are sealed routinely?
I think routinely, yes, ma'am. After the fact, I mean, they're used, they're discussed, and it's, of course, in a civil case.
I just have never. I mean, I'm just haven't operated in that situation where that was the case. So,
well, when you think about it, in a court-ordered medical exam in a civil case, you wouldn't expect that to be on the internet, would you?
Did your group propose a rule that would cover what you're trying to do?
Yes, it's in our response. It's a one-line rule that just says...
A one-line rule that says what?
I'll have to look to get it correctly, but it says, in criminal cases, psychological and psychological evaluations are confidential. Psychological or psychiatric evaluations and treatment records filed in a criminal case.
but you've really said something that hits home and what we've been struggling with for all these years, which is that a lot of these records, let's just take in civil cases, are be routinely either filed or part of the record, certainly record on appeal. And we talked about practical obscurity if nobody goes and looks at the file.
That's correct.
The issue of it being, quote, on the internet is the part you're concerned with, but the way we've addressed this is we can't, we are going to have to face the fact that with the advantages of electronic access, there is the potential for this, but we can't if we have to look, would it have been sealed under, if it was a paper record? And you're saying routinely, yes, all the time, no exceptions in criminal cases.
That's
your
correct.
representation.
It's happening when people
you're saying
catch it.
100% of the time a judge will seal that record.
Yes, ma'am. But it's often not caught. 100% of the time the judge will certainly agree to seal it, but sometimes it's already in the file and no one saw it, or sometimes someone forgets to file the notice timely and it gets filed. But I'm hoping Mr. Regensdorf will tell us how the judge in a case-by-case basis can make this determination.
I think it's time to hear from him. Thank you.
Thank you.
Please the court. Paul Regensdorf of Holland Knight in Jacksonville, appearing today for the Florida Courts Technology Commission and its Access Subcommittee, which is the successor to the Committee on Access to Court Records. I served on each of those since appointed in 2006, and also the RJA, so I may not be the voice of reason, but I think I'm at least the voice of history here today. First of all, in response to Justice Perianti's question, respectfully, I think this issue was precisely before the court last July when it decided this exact question, and that is whether this court has the constitutional or legislative or rule-making authority to grant an exception to the public records law of the state of Florida and the Constitution, Article 1, Section 24, on its own. And respectfully, however wise the decision might be in many cases, not all, but many cases, to keep certain types of records confidential, respectfully, I think it was decided long before last July, but certainly last July, in a case where I participated for the commission, you don't have that authority. This is a really important constitutional type issue. When I started working on this 6 years ago, I was shocked that the court didn't have the authority that Bob wants you to have. That if you were to sit here and say, boy, that's a good idea, why don't we make that category of documents, whatever they are, confidential? Let's do it. It's just simply the fact that you cannot. Not since 1992. The people of Florida have spoken, and they have said if it's not in a court rule in 1992, if it's not in a statute effective July 1, 1993, it can be done two ways, two paths to confidentiality. One, a new action of the legislature passed by a 2/3 majority, which the legislature has not done. They haven't done it, I don't think, because I'm not sure anyone has asked. I have urged these groups, go to the legislature. That is the constitutional path for you to obtain this. There is need for comprehensive reform in this area. It hasn't been asked for. It needs to be done. I have offered on behalf of the commission, we'll help. We'll help craft it. We've got rules-making people. That's the constitutional path. Sadly, you do not have that constitutional authority, period. The second path is a case-by-case path, and that is the path that if you want to keep something confidential, in a particular case, you file a motion to determine confidentiality. It goes before a judicial officer, not a clerk. It can't be a clerk. It can only be a judicial officer who, under C9 of the rule, has authority to look at that case, that document, those parties, the interests involved, and decide whether that document can be confidential.
What about the part that concerned me in what Mr. Young said was that when a psychological evaluation is done, court-ordered, that a copy goes automatically to the judge, which ends up automatically in the court file. How do we address that? Because if it's already then public, the harm has been done.
Well, I don't know the precise path for every way that documents can get in the court file, but I have learned over these many years that there are some things that get into the court file without a lawyer seeing it first, whether it's the prosecutor, the defense lawyer, or somebody else. And that needs to be addressed, but it's not addressed through the rule. It needs to be addressed through the administrative process. If a court-ordered psychologist, psychiatrist performs an evaluation on me, God forbid they should, that report shouldn't just go to the judge. It should go to whoever side
That really just needs to be done when the order is entered to specify.
Dr. Smith, you're appointed. Don't send it to the clerk. Send it to the court, the attorney for the defendant. Send it to the prosecutor, whatever. It's not a rule issue. You don't really have that. It shouldn't be in the rule because these things come into court files lots of different ways. But it also means that the lawyers involved will have to learn a new system. They've got to be more vigilant. It's one of the reasons why, as Keith suggested, there is now a way to get things out of the court file if they do sneak in, if they do get in through the back door. And we're entering a whole new world. Practical obscurity, Your Honor mentioned the phrase. That's the way things were kept secret before because they were just in stacks of paper that nobody looked at. But now we don't have those stacks of paper, or soon we won't, or fairly soon we won't, or someday we won't, because we're going to have electronic access. And then those things need to be scrubbed ahead of time. And it's not a simple process. And you folks know it better than anybody because you're the ones desperately trying to craft all this, while we're on the other side trying to help you craft all this. And we've got to learn to live in that world. That's the world that the people of the state of Florida created when they decided we're going to have a public court system. And they should have. I mean, it's a wonderful system. We've got to work with it. We've got to struggle with it. But the solution is not, sadly, to have you folks sit up there and say, I think that's a good idea. Let's create a new one. You've decided it. That issue is done. With all due respect, there's no statute that says that these things are confidential. Clerks have always done it. Well, maybe so. Clerks have done a lot of silly things over the years. It's not a constitutional basis. Justice Quince, your question about Exception 10, because it eliminates identifying information and goes to the words clinical records, is because that statute, 916-1078, very specific and very precise. I attached to my comment here all of the previous documents that have come before this court on this issue before. That was one of the statutes raised before, and it's very precise, and it does keep confidential, not the psychological evaluations, but only the clinical records. That is the term in the statute. And so we've eliminated
what about the other statute, 394, .4615? Is that what that statute says also? That's
now you've caught me. I don't have that. I think I've addressed it in one of these documents. I will personally guarantee you this, Justice. There is absolutely no statute that says anything like psychiatric evaluations are confidential, period. In a limited context, perhaps. Under certain circumstances, perhaps. And it's those circumstances that require the intervention of a judicial officer. The 1 through 20 are what are done by clerks. You know, people making minimum wage, working their heart out trying to keep the records current, but they don't have any discretion. Those are the ones that, as this court, as Your Honor indicated, that are easily identifiable and applicable in a court context. That's the two standards. That's where we got 20. But beyond those 20, you need the intervention of a judicial officer. If we're going to interfere with the public's access to records, somebody's got to do it. And it's got to be somebody with authority, and that is the judicial officer involved. If I can digress for a minute, Justice Perriente, you began your questions to Keith by saying, isn't there a better way to do this? And you may not believe it, but I had that written down as something I wanted to talk about at the end. There has got to be a better way to do rulemaking. I've been involved, a lot of us have, in e-filing, e-service 2.420, confidentiality, big, massive confidential, complex issues. And we're doing it as adversaries, and we're doing it in ways that we can't communicate and find out what's on your mind, and we can't communicate. There has got to be a better way. I know the bar went through this some time ago. I think Paul Hill looked into it. There's got to be a more contemplative, collegial way to do it than this adversarial, file a petition, file a response.
Well, I think there are reasons probably for all the other rules, but perhaps the time has come to look at how we can address this in a way that it gives everyone a voice, but isn't something that we...
I agree. You know, the computation of time rule, I mean, how many days, do we really need to have a contemplative, collegial discussion about that? Probably not. Somebody suggests 10 days, you think 15 would be better, do we really need to have... But when you're getting into changing the court system from paper to electronic, when we're taking the confidentiality of people's private information, these evaluations do have other people's names in it. They don't want to get their names mentioned. That's not confidential. That's sensitive. That's stuff you don't want in there. But not wanting it in there is not the same as legally binding confidential information that the public doesn't have access to. Those complex issues, there's got to be a better way for the court and the bar to work together and get these issues presented to you so that you can make the best decision. God forbid it's tough enough for us to present them to you, but for you to make the slice, the tough calls, it's hard. And I got to think that if I were sitting there, which of course I never will be, if I were sitting there, I'd want to have some discussion about this more than just what little time we have in 10 or 15 minutes with a few questions back and forth. It just seems like such an archaic way to do it on these complex issues. So, bring it back to what I'm here to talk about. What I'm here to talk about is a very simple question. Does this court have the authority, should it, under our constitutional system, to write some broad, comprehensive exception for psychiatric evaluations? Absolutely not. You've already decided that candidly, but you decided it the right way. The law is perfectly clear. The Constitution is perfectly clear. And although many times it would be a good idea, and often it will have some information that should be confidential, there's no basis in the law or in the Constitution for this court creating such an exception. Unless there's further questions, I would ask that you approve the proposal that Mr. Park has brought to you today. Thank you.
If I could just take a couple quick minutes from the rule perspective on what Mr. Young has presented. I noticed two things about it. He said almost always. Well, that's a problem when we can use the word almost. The other problem with it is we're talking about 20 identifiable items that the clerk makes a decision on, and there's a basis given for every one of those. The proposal that Mr. Young has provided us has no basis. There's nothing there. There's no statute. There's no rule. And from our perspective, trying to then put a basis for having that kind of broad context for these things just won't work.
If any, other than, and I understand it's a big other, but other than the fact there isn't a specific statute, did anyone identify a good policy reason why these either should or shouldn't be confidential?
Well, I think you're going to...
I mean, maybe it never got to that subject because Mr. Regensdorf was talking about the legislature addressing this.
Here's what I think you would find with members across the bar, that we wholeheartedly agree with the principle he's talked about. I think that the legislature ought to do something about that. I really find that the fact that these records could become public is distasteful at best.
Shouldn't that be then something, and again, for the judicial branch to take a view to really, if it is something that is either an oversight, I don't see anyone from the state either objecting, I forget what they did in July, but shouldn't we just try to then craft something and get that in as a statutory change if the legislature is willing to accommodate? I mean, it seems to me that really would be the way to go if no one really has an objection about it.
Right. Well, I don't think you're going to find much in the way of objection. I could candidly say that we searched. We were trying to find ways in which these things would become confidential for some reason, and it's the support for it just doesn't exist. Now, as Paul stated, I don't know what's been done to try and follow that.
When there is an independent medical, the so-called independent medical examination, whatever they call it, that court ordered, are those in the court file?
Usually, yes, unless somebody
I just
tries.
don't remember anyone ever suggesting those be sealed.
In a civil case, those go to the parties. They don't go to the court.
Well, it would, if there was some reason to do it, that it might find its way in a court file. I would assume
evidence, but it's not as a matter of practice. Like Mr. Young is, I understand what he's saying. He's saying that throughout history, this subject matter was subject to a broad general rule of the judicial branch. Judicial officers had the authority to seal this kind of record. I mean, that's what he's saying, and I appreciate also that we don't have a category by statute, but all these things are not just blatantly filed, but there may be some that are, and that's the argument and it's a common sense kind of argument, but also we have constitutions and statutes we have to work with. Are there any others other than just this one type? I mean, certainly there must be, over the history of Florida law, categories of material that we have always considered that ought not be published to the communities.
Not that I'm aware of that hasn't been found some support for.
There's some specific statutory provision for. Nothing about children, nothing about sexual offenses, nothing at all. This is the only category that we have.
No, sir, I don't think that's exactly true either. I mean, there are over 1,000 statutes dealing with confidentiality.
I understand,
right?
But I'm just asking: is this the only one that has this common law tradition to it? That I mean, Mr. Young just didn't start being a defender yesterday. I mean, he's been doing this for years, and I mean, you understand how the system works and what is and is not protected, and those kinds of things. But is this the only one that we've run into this really confrontational kind of thing on?
Candidly, I can't think of anything else, but I'm not sitting here telling you that is the only one.
Remember, again, what we're doing here is taking, these are the automatically sealed. As you just said, there's 1,000 public records exemptions, and we couldn't possibly, I mean, that's where we're putting the obligation on the filer to identify it for the court, correct?
Correct.
Okay, and so really here, until there's a legislative change, what we really need to do in the category of the psychological evaluations, make clear through judicial education that when the order is entered, that the order does not require or mandate that a copy go to the judge until it's presented by the parties. That would solve the most of the problem of it getting into the court file unintentionally.
I would tend to agree that it's an educational issue from
So
that.
maybe we
as
can
we're finding
develop
with
a
lot of
standard order to get to the judges that will make that clear, and we can distribute that through the court's education system. And that might be another way to, at least for the time being, address something that everyone seems to think is policy-wise, it's not a good thing to be in the court file.
I think we're all on the same team. That's the interesting part here, isn't it?
Okay.
Thank you for your arguments. Thanks the committee and the commission for all the work that you do. Thank you very much.
Thanks.
The next case for the day is Philip Morris versus Douglas.
Good morning. May it please the court, my name is David Boys and I represent the defendants. And with the court's permission, I will reserve 7 minutes for rebuttal. The plaintiff in this case asks this court to do something extraordinary and unprecedented. The plaintiff asked this court to impose strict liability on the defendants without requiring the plaintiff either to establish every essential element of the plaintiff's claim in this case, or to demonstrate that an essential element that was not established in this case was actually decided in a prior case. There's no dispute that the jury in this case was not asked and did not decide whether the particular cigarettes smoked by Mrs. Douglas were or were not defective.
In Engel, if the class action went on for a year trial, if it had ended up with a judgment in favor of the defendants, would you be making the argument that the plaintiff still would have, every plaintiff that was part of the class could go back and try their case?
It would depend on the findings, but for example, with respect to finding number 3, which asked whether the defendants placed on the market cigarettes that were defective or unreasonably dangerous, if the answer to that question had been no, then with respect to strict liability, that would have been the end of the matter, because there would have been no situation where any cigarettes placed on the market were defective. The issue here is that because of the generality of the question and because of the way the plaintiffs tried the case in Engel, what they did was they offered many different alternative reasons that they described to the judge as alternative reasons for defect. Because the jury in Engel was never asked and did not decide whether all cigarettes were defective at all times, or if so, whether or not they had a common defect, and if so, what that common defect was. Because you don't have that information, because those decisions were not actually decided, you can't take that finding and use it to impose strict liability in the subsequent case.
What did this court mean in Engel when it said that finding, that the defendants placed cigarettes on the market that were defective and unreasonably dangerous, would have res judicata effect. It seems like your argument gives that determination of this court absolutely no effect.
No, Your Honor, I think what this court did in Engel was to decide which findings would have preclusive effect, not to decide what that preclusive effect was. That finding has preclusive effect. It is not possible for a defendant to come in and counter that finding. But that doesn't answer the question as to what that finding means. For example, if that finding...
But it seems to me that you're saying it effectively means nothing in any subsequent case. I'm trying to understand how in any subsequent case that finding could have any sort of preclusive effect that would mean anything.
I think, Your Honor, it means very little. I think that as
maybe so little as nothing?
No, not so much nothing, Your Honor. I think as the 11th Circuit held in the Bernice Brown case, what it does is it precludes the defendants from saying they never marketed any defective cigarettes. But the fact that it may have limited relevance, that particular finding may have limited relevance going forward, is not a reason to give it a substance that it was never given by the jury. The jury never decided this question. For example, ask yourself, what was the defect in Mrs. Douglas's cigarettes? Now, why do you need to know that? You need to know that because if you don't know that, the jury cannot answer the legal cause question that this court said had to be answered in the subsequent trials. If you have a single jury, all you have to do is ask that jury, was the product defective and did that defect cause the injury? But when you're trying to take one jury's finding and transport it to another jury's case, the second jury has to know what that defect found was, because if they don't, they cannot do the legal cause decision that this court in Engel said had to be done.
Maybe, and I have to go back and look at everything in Engel, which was several years ago, but I thought that the defect had something to do with putting unreasonably high levels of nicotine in the cigarettes that then both created, and other additives that created pleasure and became addictive. And that the issue, though, that we said was that what a plaintiff would have to do to get to damages is just show that as a result of the cigarette smoking, that they had developed lung cancer as opposed to as a result of exposure to asbestos or something else. So that legal causation was required. And we were very clear about some of the other findings that we said would not have any effect. But are there other defects that I'm missing about cigarettes, and what the Engel case on behalf of a class-wide group of smokers, there were what other defects we were talking about with cigarettes?
There were a number of other defects we discussed.
Well, the warnings were found to be, and fraudulent concealment for years and years, those were all found.
I'm not talking about those. I'm talking about the design defects, which is what I thought the court was talking about. And the court is exactly right that one of the defects that was alleged was that for some brands, for some periods of time, they used genetically modified tobacco that increased the nicotine levels. Another defect that was alleged was that certain brands at certain points of time had ammonia added to them that made the product defective. Another theory of defect was that because filters could filter out harmful byproducts of smoking, that it was a defect because you had high nicotine and tar levels in the absence of filters. Not having filters was a defect. Another defect that was alleged was that the filters, when they were put on, had defects.
So you're saying there were different periods of time that the cigarettes had different things, but wasn't that then a failing of the Engel defendants who had, how many pages of interrogatories did the jury have in Engel?
Well, on this...
it sounds like this would have been a very good argument to have made at the time of the Engel trial to get, listen, we're only going to agree that this defect existed for these 5 years, for these cigarettes. We're not going to all band ourselves together and just defend on the basis that cigarettes are perfectly fine.
Right, and one of the things the Engel defendants did do was they asked the court to impose a very detailed jury questionnaire saying what was the defect and when did it apply, just exactly what the court is suggesting. The plaintiffs in Engel, though, and remember the plaintiffs in Engel weren't looking towards the progeny cases. These progeny cases came out of this court's Engel decision to treat what happened there as an issues class. They weren't thinking about how this is going to be applied in that way. And they asked the court to give a general. In fact, they argued against specificity. And the reason they said we have many alternative theories, several alternative theories. Those are the plaintiff's counsel's words in Engel, not mine. And because they're alternatives, this court can't know which, and no court can know, which theory was adopted and which wasn't. What you do know is that those theories did not apply to all cigarettes, did not apply to all periods of time. And
but they did apply to the cigarettes manufactured by these defendants.
They applied, as the 11th Circuit
these
noted,
defendants as opposed to other manufacturers.
Exactly. They applied to some cigarettes. In other words, each of these defendants was found to have placed on the market some cigarettes that were defective.
Your theory then is going back, is that someone must go back and find the ashes of the burned cigarettes to prove that that burnt cigarette contained a defect as a condition preceding to recovery in this case, because you have to prove the particular cigarette contained X, and X was the cause of death for Ms. Douglas.
You have to prove that the particular
That's
brand of cigarettes. You don't have to go back to that.
Well, they did do the brands. I mean, that was the whole point of Engel, as I understood it. You're saying they have to go back to the particular cigarette.
No, Your Honor. We're not saying they have to go back and find the ashes for the.
That's what you're saying. It must be the particular defect in the particular cigarette.
Yes, but what I'm saying, Your Honor, is that the defects that were alleged were defects in particular brands of cigarettes. For example, certain cigarettes had ammonia added to them. Certain cigarettes had never had ammonia added to them. Certain cigarettes had ammonia added to them for some periods of time and not for others. The same way with the genetically modified tobacco that was mentioned earlier. There were obviously times when filters were available, times when filters were not available. Some cigarettes had the filters with charcoal. Some had other kind of fibers. Different arguments were made to the Engel jury about why each of these things were defective.
But I guess what we're still looking at, and it goes back to what Justice Kennedy said, of what we thought we were doing in Engel, and what was being argued that this should not have been a class, and that was what the third district said. A class, if you were in the class, which we said was defined for, it was a specific period of time with specific manufacturers, then you had the benefit of the liability verdict. Now you're saying no, all you had the benefit of was that you could use anything in that record to pull it out and then retry liability again. I think, is that what you're saying? I mean, it sounds like that's what you're saying. In other words, that what you could use is you'll take the expert that testified and you could use that, but you'd have to go reprove your case. You're not saying that they have to reprove their case?
Well, it depends on how much of their case was proven in Engel. Let me give you the court an illustration. One of the findings was which diseases are caused by cigarettes. And the jury went through and identified 20 diseases that were caused, 3 diseases that were not caused. If you had done that, and that finding can be easily used. If you'd done that with defects, you could also have used and easily applied it. For example, if they had said 20 of these alleged defects are defects, 3 are not.
All right,
we would know.
So now again, we're going back to what you would say is that we need to go back and see who caused these findings not to be as detailed, and then on appeal, was that raised by the defendants as a ground for not giving this class action preclusive effect? And because I feel like we're hearing an argument from the Engel case is what I'm feeling.
I think not, Your Honor, because I think the Engel case decided which findings, and the court used the term issue class. That is, which of the issues that were decided.
But the court wasn't using issue class in the context of collateral estoppel or res judicata. It was talking of it in terms of liability issues and damage issues, not segregating out defect issues. But you must agree with that.
Well, Your Honor,
you don't agree with that?
I don't completely, and Your Honor, because what the court did hold was that legal causation, indeed all causation decisions, were to be for the second jury. And you cannot have liability without legal causation. So I don't think it's accurate to say that
you're saying that
the
court did not mean what it said when it said that you're going to have res judicata effect on these findings of defects.
No, Your Honor, I think the court meant that those findings were going to be preclusive, but they're only preclusive as to what they actually decide.
You're just saying it in different words. I mean, you're circling back around. You're saying exactly what I said. Okay. It's just you're trying to use pretty words to avoid confronting it. And that is that there is a difference between issue preclusion, collateral estoppel, and res judicata.
Well,
is there under Florida law? There is there not?
Under Florida law, as just for example, as the cases that we cited in footnote 2 of our reply brief, as this court's decision in 1981 in the Florida Department of Transportation case, 801 Southern 2nd 101, holds, and just says, is that res judicata is an umbrella concept. It includes both issue preclusion and claim preclusion. That's the same point that the 11th Circuit made in Bernice Brown.
Well, I think you better look at some other cases because Florida does distinguish between issue preclusion, collateral estoppel, and res judicata.
Certainly distinguishes between claim preclusion and issue preclusion.
And it really would help if you would respond to the question I asked rather than trying to go around it, because I still never got an answer to my original question.
Okay, I'm sorry.
You're very good at doing that, and you're a great lawyer, but I still got no answer to my question.
Let me try again, Your Honor, and I apologize. The precise question that you're asking is what? Let me try to deal with it precisely. What is it?
No, you've dealt with it.
Okay, I really want to respond because this is something in which I know that the court what the court would like to do here, and I appreciate that. And what I'm saying is that those findings have certain effects, but they can only have the effects as to what was actually decided. And if you think about what this court did, and the reason I went to the issue of legal cause is that this jury was never instructed as to what the elements of a strict liability case are. I mean, one of the elements of liability is that the jury has got to find that the defect caused the injury. Now, if the jury has made the decision that the product is defective, it knows what that defect is and can then apply it. If it's taking something from an earlier decision, unless there is the particularity, as there is in the disease finding, that tells you what defects were found or what diseases were found, depending on the finding, the second jury can't know that and can't apply that. And because of that, you cannot determine whether it was actually decided. The rule has been in this state, in every state that I know of, that where a plaintiff wants to rely on a finding in a prior case, the plaintiff must prove with reasonable certainty, that's the language of these courts, Florida courts, that issue was actually decided in the prior case. You can't do that here. And a good illustration.
Down to about 2 minutes left for your rebuttal.
Thank you, Your Honor. I will reserve it.
Morning, Your Honors, Counsel. May it please the Court, I'm Steve Brannick of Brannick Humphreys, representing plaintiff Douglas. I think Mr. Boyes has been very transparent in what he's asking the Court to do, which is essentially to declare that the Angle 1 largely a meaningless exercise, or close to zero, as you put it, Justice Kennedy. Those misconduct findings, the findings of fraud and negligence and defect, were litigated for a year. This Court then had an opportunity to determine whether those findings were class-wide findings that were applicable to all of the plaintiffs in the case, determined that there were, and then held that they would have res judicata effect. Their argument essentially is that res judicata effect means nothing, and that all of the thousands of class members have to retry defect, negligence, and fraud in all of the thousands of other cases that are coming down the line. That can't be what this Court meant. All of the district courts of appeal who've been struggling with these cases have reached the same conclusion, that res judicata means res judicata, that the misconduct findings are in fact settled.
So it's your position that this finding 3 regarding the defective and unreasonably dangerous condition of cigarettes that the defendants placed on the market was a finding that all of the cigarettes the defendants placed on the market were defective and unreasonably dangerous?
All the cigarettes that were sold to these class members. Remember, the class members are those members who are addicted, and that addiction causes an injury. So we're talking about the cigarettes that were put on the market by these defendants that caused addiction, and when used repeatedly, results in injury or death. Yes, all of those cigarettes were defective.
Okay. Well, my question is, how do we know what cigarettes those are? If it's not all of the cigarettes sold by all of the defendants, how do we know that the cigarettes that were defective were cigarettes that were used by Mrs. Douglas? Because of the way this is worded, it seemed it's a kind of a puzzling way to word this finding, because it would have been easy to word the finding so that it was clear that it covered all of the cigarettes that the defendants placed on the market, but it doesn't really say that. If it had said that the cigarettes the defendants placed on the market were defective and unreasonably dangerous, that'd be one thing. But that's not what it says. It says they placed cigarettes on the market. Well, that seems to not be an express statement that it's covering all of the cigarettes they placed on the market.
The reason we know that she was injured by these cigarettes that were at issue was because of the class definition. In order to partake of those findings, she has to prove she's a member of the class. And to prove that she's a member of the class, she has to prove that she was addicted to those cigarettes. That ties directly back into the claim that the plaintiffs were making, that the defect here was the sale of a highly addictive product coupled with the fact that when you use it repeatedly, it causes injury. If we're not talking about cigarettes that aren't addictive, because then she wouldn't be able to prove that she was a class member, because she wouldn't be addicted. So that's where you get the connect. It's the finding of addiction connects to these particular cigarettes. What I think is important for the court to understand that this was a class action, and it was litigated as a class. And the jury was told, you are making class-wide findings that are going to be common to all of the plaintiffs.
Yeah, I think what we did in Engel was the plaintiffs were saying that there shouldn't even have to be legal causation, that they should just proceed to damages. And we rejected that because it seemed that link had to be made individually. I wanted to, though, ask you about Mr. Boyes' statement that during the period of time that's covered by the class, some cigarettes had genetically engineered, in other words, were worse than others, and that the findings of the Engel jury as to this were not specific enough to allow those findings of strict liability and defect to be used in a subsequent case. Could you address that? In other words, like if the finding had been, and all these cigarettes had the genetically, from the period of time to whatever the period of time, and be very specific about what the fact was about what was being put in at a particular point in time.
I think the bottom line is that there's just a fundamental misunderstanding of how this case was tried. The jury was not asked to decide brand particular defects because this was a class action.
Well,
on the plaintiff's side,
what I'm asking on the defendant's side, because I always wondered about that. This all occurred after I became a judge, and how this all evolved. Did they want there to be differentiation between the different manufacturers? That, for example, Philip Morris, who's here, they marketed their cigarettes differently. How did that work in Engel, and then therefore for us understanding as to Philip Morris and the period of time we're talking about, whether it's unfair to bind them to these findings?
The answer is they had absolutely no interest in distinguishing among their brands. They were all in. This was an all-or-nothing defense. Their argument was that none of these cigarettes were defective for the many reasons they discussed. They never presented an argument to the jury that some cigarettes were safer than others or some cigarettes were more defective than others. It was an all-or-nothing approach. They thought they were going to win. They announced to the court that we want there to be preclusive effect because they were convinced they were going to win in front of the jury. Well, the jury disagreed with them. But they argued it all or nothing, just as the plaintiffs argued all or nothing. These various micro defects, as we called them in our brief, are all variations on the same theme, which is this was all evidence of how tobacco manipulated the nicotine and the addictive level of the cigarettes. But it's all the same defect. It's the addiction coupled with the disease causation.
What was the stipulation in this case? Did they stipulate on addiction, or did that have to be proved?
That had to be proven. They stipulated that her COPD and lung cancer were in fact caused by smoking the cigarettes, but they did not stipulate to addiction.
And the jury had also found she was a member of the class?
Absolutely.
And what did the class meant that she smoked cigarettes for what period? What was the period of the class? In other words, did she have to show? They were talking about things that happened maybe prior or subsequent.
Right. There wasn't any issue in the case about whether time-wise, she was a member of the class. So what she had to prove is she was addicted, and there was a very powerful case of addiction shown in this case.
Because what I'm thinking about, if we hadn't decertified the class, she would have been able to continue in the case in Miami.
Absolutely.
And then go to phase 2, just like the plaintiffs that did. Right. And it would sort of be, that's what I'm thinking, if at that point someone had said, well, you now have to reprove your case, and I think that's what I'm trying to look at it, that this is really a continuation of Engel with the idea that you have to, not everyone's going to get to recover. You're going to have to go through a lot more hurdles to get there.
A lot of work. I mean, these are long trials. This was a 2-week trial. It was one of the shorter trials.
But again, the length of the trial can't be the deciding factor on the legal issue. And why is the defendant not correct that you cannot have liability findings in the air without some nexus to damages? And that's why the defendant's argument is, well, okay, you have found that this coffee cup may have some defects, but the preclusive effect of finding that defect doesn't necessarily translate into, if Justice Kennedy picks it up and happens to be injured by it, that you still need the nexus, as I understand their argument.
Well, and the critical nexus is whether the defect was applicable to all of the members of the class. And the defect that we're talking about here, the addiction coupled with the disease causation, is in fact a defect that applies to all of the class members. And so every class member, including Mrs. Douglas, had to prove that they were, in fact, addicted. There's often a very big fight about that.
I don't understand your point about that, because she could be addicted theoretically because she used one particular type of cigarette that was made by one manufacturer that had nothing to do with the other cigarettes that she used, or she could theoretically she could be addicted for some other reason. So I don't understand how the fact that she's addicted to cigarettes necessarily shows that the cigarettes that the cigarettes that she consumed from all of the defendants were defective and unreasonably dangerous. I don't understand how that logically follows.
Because all of the cigarettes contained that same defect. There wasn't any argument.
But did the jury find that? I mean, I understand that's your position, but what I'm struggling to find is a finding by the jury to that effect.
All right. 2 points. First, we know that's what the jury decided because first, that's how the class was defined. The class was defined with a focus on addiction. Secondly, we know how this case was argued. It was argued by the plaintiffs, addiction and dangerousness. And the defendants defended exactly the same way, saying it's not addictive and they're not dangerous, or at least science hasn't yet proven whether they're dangerous, which is incredible that they were still doing that in the year 2000, but they were. Then we have a jury that was instructed that they were deciding common issues that were applicable to all of the class. Now, we have to presume that the jury, in fact, followed those instructions. And then if you look at the closing arguments in the case on both sides, you will see, again, these are all or nothing arguments. Nobody was focusing on those micro defects. Nobody was focusing on distinctions between the brands. Tobacco was saying none of these cigarettes are defective, and the plaintiffs were saying all of these defects are defective. And then finally, I think the trump is that in Engel, this court had the entire record in front of it, and one of its tasks was to determine, should this class be certified? And you answered yes. And the only way you can answer yes to that question is to reach a satisfaction in your own minds, based on a review of that record, that the findings were sufficiently applicable to the entire class, that it was not unfair to give them a res judicata effect going forward. So that's the first part of the response. The second part of the response is if they didn't think that the jury verdict form was going to adequately protect them, then they should have offered a different one. They offered an initial jury verdict form that was clearly improper under Florida law. It asked narrative questions, had fill in the blanks, and the trial judge properly exercised his discretion and said that wasn't right and proper. They could have appealed that. They didn't. So they could have. Then the trial judge asked them on several occasions, well, if you don't like this jury verdict form, give us something that you can live with. They never presented something. And the law is very clear in Florida. If you're going to complain that the jury was improperly instructed, you've got to put forward the proper instruction.
I don't think they're necessarily claiming that the jury at that point was improperly instructed. They're just saying that what the jury found does not support your position.
But
and it still is a mystery to me why that finding is worded the way it is worded. Because it would have been so easy to have a finding that all of the cigarettes that were sold by the defendants were unreasonably dangerous and defective, but that's not what it says.
That's correct. But remember, they knew that this was just phase one of multiple phase trials. So when Mr. Boyd says we didn't have any idea that these progeny folks were coming along. Well, that's completely not true. Everybody knew this was just step one of a process, and that all of these plaintiffs were going to have their individual day in court. So they knew that there was going to be a preclusive effect given to those findings. And if they thought that they were going to be that it was going to be unfair for those findings to be given preclusive effect because they weren't specific enough, then it was incumbent upon them to provide a more specific finding. They could have appealed that in the Engel 1 case. I mean, they raised the due process issue. They raised exactly the same issue.
I'm looking at, I don't have the briefs in front of me, but we agreed unanimously that the non-specific findings in favor of the plaintiffs on question 4, fraud and misrepresentation, 9, intentional infliction, are inadequate to allow a subsequent jury to consider individual questions of reliance and legal cause. Therefore, these findings cannot stand. So if I look at what we say about phase one, and this goes just back to it, it would be sort of a novel thought that what we were saying as to the phase one addiction and strict liability, which is 1, 2, and 3, were not to be given preclusive effect. And obviously we've got to first look at what we said in Engel. If we were wrong in Engel, then that's what maybe we're being urged to recede from Engel, and that's I don't know if that's something that has been expressly asked to do. Did you get that as being one of the things that we should recede from Engel?
I think, in effect, what they are doing is appealing Engel 1 all over again. When they had their opportunity to raise these issues...
Well, was there an issue in Engel about the jury findings on strict liability not being specific enough?
They, in fact, raised that argument in their rehearing motion to this court, and it was rejected. And then they went to the U.S. Supreme Court, and they presented precisely the same due process issue that's in their brief here. They presented to the U.S. Supreme Court, and the U.S. Supreme Court denied cert. They've presented that same due process issue again to the U.S. Supreme Court this year in the 4 cases that have finally, after 18 years, wound their way all the way through to the end of the court system. And again, the U.S. Supreme Court denied cert.
How many class action plaintiffs have been, or subsequent, how many trials have there been in the state of Florida?
As of the filing of the amicus brief has a nice little chart on that. I think it was 79. There have been a few more since then.
And are they? And there were about a third that were found for the defendant.
That's right, about a third. And if you include the mistrials in that, then it's closer to 45%. So these are hard-fought cases. There is a full vetting of the causation issue. It's usually vetted in connection with the class definition, which is the proof of addiction. Generally speaking, the defense tries to argue to the jury that they're not a member of the class because it was their own personal choice and not addiction.
On the class definition, are brands of cigarettes identified in that, or is it all cigarettes that have nicotine? How does the class definition decide on that?
The class is defined as all Florida citizens who have suffered from diseases and medical conditions caused by their addiction to cigarettes that contain nicotine. So it's a very broadly worded
but
class. It's not brand specific.
Was it every the defendants were presumably, how many defendants were there? Because I thought there was one defendant that was found not liable.
There were,
or two.
On some of the issues because they had not participated fully in the fraudulent concealment. I don't remember exactly.
So they
how
made
many
I mean, the point is they made distinctions. But what you're saying, when it came to the actual liability findings, they didn't ask to be separated to say my cigarette was better than.
Absolutely, because they had no interest in doing that. Because they were all in. They wanted the jury to find that none of their cigarettes were defective. They had no interest in arguing that one particular cigarette was safer than another.
And the agreement is,
and
it's conceded it, if they had found no, that would have been the end for Mrs. Douglas and all the members of the class.
Right. So it's heads I win, tails I win. I mean, that's basically the argument that's been made here today. The fundamental bottom line is that they had a full and fair opportunity to litigate the question of defects, including a full and fair opportunity to develop the jury verdict form that they knew was then going to be used in subsequent cases, whether it was as a continuation of the class action or in this separate progeny litigation. They had that full and fair opportunity. They lost. Then they had their full right of appeal to the 3rd DCA and to this court where they raised some of these exact same issues, and this court rejected those issues. And then they had their opportunity to go to the U.S. Supreme Court. Now, for the life of me, having gone through that process, to suggest that they can then go back to the trial courts, same parties, same claims, and litigate those things over and over again thousands of times, that would be a fundamental violation of the plaintiff's right of due process. I think this court came to a very sensible middle ground in the Engel decision in giving those findings res judicata effect. This court knew that these cases were tried as a class action, had the entire record before it, saw how the cases were argued, saw the evidence that was presented, saw how the defense handled it, saw all of that, and it decided that these particular findings had a class-wide effect, and therefore it was quite fair to grant them a res judicata impact. I want to just spend a minute more specifically talking about due process, because that's, of course, the certified question that was here before the court. And it's amazing how small a feature it is in their brief. And I think it's a small feature because it's been rejected so many times. But I'd like to go back to their Fayerweather case, their centerpiece case, which they say supports their due process claim. The Fayerweather case is an awful lot like this case. There was a general verdict in a will challenge case, and it was tried once and lost in the state court. Then they tried exactly the same case in federal court, and they said, wait a second, there was a release issue, and the trial judge never reached this release issue, so we should get the right to try this case again. And even better for the defense than in this case, they had an affidavit from the trial judge that said, I never looked at the release case. I never looked at the release issue. And the U.S. Supreme Court said, that doesn't matter. These parties have fully and fairly litigated this claim, and it litigated to a general verdict, and we don't look behind that general verdict. All of the defenses that were raised or could have been raised are now considered to have been fully disposed of, and the court affirmed the application of preclusion in that case. So I think it is absolutely very poor support for their argument. For all of those reasons, we think that the judgment of the jury verdict below should be affirmed, and for the reasons that we discussed in our brief, we think that the way the jury instructed in this case was appropriate, and that should be affirmed as well. Thank you.
Thank you.
Let me try to be very clear about a couple of things. First, we're not asking the court to depart from Engel. Second, we're not saying that any of the findings that the court held were appropriate for class determination should not be given preclusive effect. All we are doing is we are saying what Florida law has always said and what federal due process law has always required is that before you take a finding and apply it in a subsequent proceeding, you must be able to determine what the jury actually decided, and you must be able to determine that with reasonable certainty.
Do you think, can that be, if the tobacco industry fully participated, I mean, not the defendants that included your defendant, fully participated in the year or 2 year long proceedings and got to raise every defense that they possibly could raise to why their cigarettes were not defective, that there was no basis for strict liability? I am, as far as the due process issue, I'm having, we may differ as to whether Engel findings should have been a little different, but as far as the due process issue, where is there a constitutional violation, which is the certified question?
Because Your Honor, the constitutional requirement is that the plaintiff be able to establish each essential element of its claim. That's due process under Fairweather and a variety of other cases. And they've got to be able to establish, if they're going to use a prior case, that the issue was actually decided in that case.
But you see, here is, I think, where we may be departing, because this plaintiff was part of the class. We could have said the case continues in Miami, Florida, with individual trials for everybody who's part of the class. And isn't that real? This isn't like she's a different plaintiff. She was part of a class that's now continuing, probably from administration of justice, thank goodness for Dade County, right, that it's being tried in different places.
And because she's a member of the class, she gets the benefit of those findings, but she only gets the benefit to what the findings actually say. It would have been very easy for them to say all cigarettes are defective. They didn't want to do it. It is not true that this was all or nothing. We asked to have them specifically identify, fill in the blanks, which brands were defective.
But why doesn't the class definition, as argued, include that? All cigarettes that have nicotine. Very broad.
The jury wasn't asked, though, whether having nicotine and causing disease made it defective. And remember, under Florida law, you've got to prove it's unreasonably dangerous. It's not enough that it simply causes harm and is addictive. And even if Florida law were different, federal preemption law would prevent that ruling. So they couldn't have asked. They didn't ask whether addiction plus disease equal defect. They didn't do that. It would have been very easy for them to do that if they'd wanted to. They didn't want to because they wanted to get a yes answer. This was a case that was tried to get a large punitive damages award. And what they were trying to do was get as many yes answers as they could. That was their trial theory. No one is saying that they cannot use the findings for what they say. What we're saying is they can't make the findings something that they're not. And you've got to look at the findings, and that's what the court did in Fairweather. Fairweather, the court went behind the general verdict and looked at what was alleged. And what they found was that there was only one theory. Here, there are multiple theories, and because they are alternative theories, you cannot find what the jury actually decided, and without knowing that, you can't do the legal causation issue that this court specifically in Engel said had to be done by the second jury.
You're out of time. Thank
Thank
you
you,
for your
Honor.
arguments. The court will take a 10-minute recess at this time. Thank you.
All right.
Our next case for the day is Hilton versus State of Florida.
May it please the Court. William McLean representing Gary Michael Hilton. Mr. Hilton was convicted of first-degree murder for the death of Cheryl Dunlap here in Leon County. She went missing. Her body was ultimately recovered in the Apalachicola Forest. Mr. Hilton was ultimately connected to the crime through DNA evidence and some statements that he made to an inmate while in jail. After the penalty phase of the case, the jury recommended a death sentence, and I would like to address and spend my time this morning on one issue, and that's issue number 2 regarding the penalty phase of the case. And in particular, that issue involved the introduction of allegations of collateral crimes through the testimony of the state's expert, Dr. Pritchard. Mr. Pritchard was permitted to testify to allegations of uncharged, unsubstantiated prior crimes that included fraud, theft, and most inflammatory, sexually molesting children.
Now, let me ask you this. Did the defense, during the course of this, present evidence that indicated that Mr. Hilton had no history of any kind of activity prior to this murder?
No, that was not the case.
That was not the case.
The context here, the defense presented a mitigation case with 4 experts, and they all testified that Mr. Hilton, all 3 of the mental health experts testified. There were 3 mental health experts and a pharmacologist who testified. The 3 mental health experts testified that Mr. Hilton suffered from brain injury, he suffered from schizoaffective disorder, and he suffered from antisocial personality disorder. And they, in fact, talked about some of the troubles that he had had through his life, legal and otherwise.
So there was testimony during the defendant's presentation of evidence about some of the
prior cases that he had had. There was some testimony about ones that he had been charged with or convicted of, but it was mostly property type crimes. Other than when he was a juvenile, he did actually used a shotgun and shot at his abusive stepfather, who at the time, in the context, he was actually trying to defend his mother from from this person who was controlling and overbearing. And in fact, when he asked him to leave, because his mother and the stepfather were estranged at the time, and at 14 he was stepping forward and said, leave, and the man instead pulled a mattress from the bed and held it in front of him and taunted him and said, "Go ahead and shoot me." So he fired the gun. There was no indication anywhere in the record that there was any substantial injury as a result of that.
How old was he at the time?
He was 14.
No, at the time of the crime.
At the time of the crime, he was 60.
60.
60 years old.
And he had an IQ of, 120?
I think it was 120 for verbal, 105 for nonverbal, although he had some difficulties with attention issues and other learning problems as far as attention problems were concerned. But yes, he was bright. He's a bright man.
Are you going to start with issue 1?
Said issue 2.
Well, I was going
to
deal with issue 2, but giving them more context, these mental health experts had testified about this.
Well, you're not, so as far as I just want to, so you're not going to issue 1 is your only liability issue.
That's correct, and I'm in no way casting that aside, and I am going to kind of link that in with the issue 2 because it carries over both the guilt and the penalty phase issue, the admission of that statement. That admission of that statement was during the course of Mr. Hilton talks a lot, and they recorded these conversations while they were executing a search warrant and that sort of thing. And in talking to the police officers, he at one point says, "I'm going to give you something," and says, "I didn't start hunting until September."
And what does that mean? I mean, you say that this is really information about prior bad acts, basically. But what in the world does a statement like that mean?
Well, that's a good question. And the context is that the murder in this case occurred in December of 2007. There was a murder in Georgia that he had already pled guilty to in 2000, that occurred in January of 2008. By the context of him talking about, "I didn't start hunting," meaning hunting for victims.
Wait, he had already pled guilty at the time he was being driven? No, but we're talking about the comment that he made in the car.
Yeah,
where he says, and yes. I had that same, which is, like I said, when I saw you before, I said, "Remember that I give you 1 for free, nothing before September, okay? I mean, I'm not joking, okay?"
Yeah, they were already serving a search warrant, and the Georgia case, he entered a plea very quickly after his arrest.
But it wasn't at the time. So answering Justice Quince's question, what do you think that meant? And how was that harmful that he stated that?
It was harmful in that it suggested other crimes besides the ones occurring in December and January.
It's pretty ambiguous. Because I couldn't figure out what that meant unless there was more context.
More context, and I'm really going to hammer it again when I do move on to issue 2.
All right, I just want to, on issue, they kept out of the guilt phase the Georgia
murder. That's correct.
That occurred after.
That's
so
correct.
That's would have been a critical issue. And did the state try to get that in, or they didn't even try to put that into evidence as a?
I think there was ultimately an agreement not to use it in the guilt phase. It was used in the penalty phase.
Right, which is obviously appropriate, and that was a good decision because now we don't have that as an issue.
And as far as the guilt phase is concerned, the argument is that I didn't start hunting till September implies other crimes before this one in December. And in fact, Mr. Hilton has other offenses in North Carolina, which were not yet. Were not yet. He was a suspect at the time of this case.
Was the jury ever told about the other offenses?
They were not.
No. Okay.
They were not. Not the one in North Carolina. No. Okay. Those were. He was still just a major suspect at that time.
You want to get to Dr. Pritchard?
I want to get to Dr. Pritchard, and I'm glad we talked about issue 1 because the hunting comment re-raises itself in issue 2 in the way Dr. Pritchard tied it together with some other improper evidence, and it became very inflammatory.
Now, I'm understanding that the argument is they opened the door by saying until this happened, this December murder, he had lived essentially a crime-free, violent-free life. Isn't that what the
That was not
was?
the defense.
In the penalty phase?
In the penalty phase, they acknowledged that he had problems. They acknowledged at 14 he'd actually discharged the firearm. They acknowledged that...
Well, you sound like that one, though, was to help his mother, so it doesn't sound like that's a particularly bad act.
The argument was that what happened with his... Maybe I should put some more context around the mental health issues, because they said he suffered from the frontal lobe injury, he suffered from schizoaffective disorder, he suffered from antisocial personality disorder. They all agreed with that. And now, what they're saying is that was a base level of mental impairments, if you will, that Mr. Hilton had, and but he managed throughout his life, even though he got into some scrapes, did some property crimes, he would occasionally get confrontive with people, and there was evidence of aggression, and he did get, and that sort of thing was going on. I mean, he did not have a trouble-free life.
But didn't they say
he had
that
some
I
control
thought
over it.
That there was a claim that he'd done nothing wrong, and the change in character was created by the Ritalin?
Not that he had done nothing wrong before then, but he had the escalation to murder occurred after he was improperly treated with Ritalin and the antidepressant Effexor, which apparently in combination can create psychotic symptoms, bizarre things. That
even though he got into minor scrapes, as you put it, that it wasn't essentially a violent person as this crime would have indicated.
Yes, the level by getting up to the level of this crime occurred. That kind of problem occurred because he started deteriorating in 2005 when a physician in Georgia improperly treated him with Ritalin and Effexor in high doses.
And that was
that's the trigger
was the
date.
defense, that he deteriorated then. So what's wrong with the state being able to, on rebuttal, say, absolutely not. It did not start when he was 59 or 58. It started, and there were indications throughout his entire life based on misconduct that preceded the exposure to Ritalin. I'm not... Now, maybe they went too far in what they were allowed to refer to, but the idea that that's proper rebuttal and that you open the door by saying it started then, shouldn't the state be able to rebut it by saying that he had a lifetime of very questionable behavior?
Well, there's two key pieces that Dr. Pritchard went into. Now, he went into the fact that he had some prior arrests and that didn't turn into convictions for, I think there was an assault, there was confrontations with people, there was property crimes, there was fraudulent activity.
And you agree that those occurred and they were appropriately put into evidence?
I don't think they were appropriately put into evidence because they were arrests and allegations, not convictions, number one. But even if they were, I think two pieces of Dr. Pritchard's testimony went way beyond the line, and that is when he, referencing a police interview of Hilton's ex-wife back in the 70s, as I recall. Not the interview in the 70s, but in investigating these cases, they interviewed her, but she was married to him briefly back in the 70s, a second marriage for her. And she had 2 children. And according to the interview to the police officers, she testified to this fraudulent activity went on with him, but she also said, and he sexually molested my children.
Okay, now that is something I want to... Was the objection made that the state did not establish that actually occurred, or that allowing it to be introduced through Dr. Pritchard would be unduly prejudicial?
Well, it's both.
What was the objection?
It's both because...
No, I'm asking, what did the defense lawyer say? Because I see a distinction between saying that Pritchard can testify to the fact that this change in Ritalin was not the operative thing, that this guy had done a lot in his life. On the other hand, allowing something in that's questionable as to whether it even occurred, which is hearsay of a wife from the 1970s about molestation or possible molestation, to me is a different issue. It seems like you combine both of them, and I want to know what was the objection at trial.
The objection throughout had been to collateral crimes evidence coming in.
But isn't that different objection to say this is a collateral crime versus there's a real question as to whether this occurred? That is, that there's no competent evidence to substantiate. That's why we are always concerned about arrests, but certainly an ex-wife saying something in a report, we don't really think that would be allowed into evidence because you can't cross-examine it and it's presented as a fact. Was that
That's
the
what happened.
objection? I understand that happened. I'm asking if that was the objection.
As I recall the objection at that moment, it was an objection. They were talking about collateral crimes, and I believe it was a collateral crimes objection. There was later a motion for mistrial was made about the introduction of this testimony and the other testimony.
Do you appreciate, as an experienced appellate lawyer, the difference between saying this collateral crime evidence shouldn't come in when you are trying, as the state, to rebut a claim that this only started recently, versus that you can't allow in through the back door evidence of a possible molestation because there's no evidence it actually occurred? Do you? And I think in Robertson we made that distinction between how you do that, but there's got to be an objection based on that for the judge to be able to rule on it.
The objection, at that point, it was, again, a collateral crimes objection, and ultimately a motion for mistrial was made. Whether in the heat of trial they parsed all that out or not, I can't recall at the moment without looking at the motion for mistrial.
Were they surprised? Was Dr. Pritchard...
It was a surprise.
Did Dr. Pritchard learn that because he was in the courtroom, or is that something that he had?
He did not learn it in the courtroom because that never came out in the courtroom. Right. He was allowed to stay in the courtroom because during the penalty phase, but he learned that from reading the materials that he was given.
Did he have a report that
He had a report.
Did that include the charge of molestation?
It had the ex-wife statement that included that, among other things. So how could that be a surprise
to the defendant?
I think it was a surprise that he was going to testify about it. Because
then when you say heat of trial, this is a death case, and it's a penalty phase. Was a motion in limine made about that particular allegation?
Not that particular allegation, no. Now, there was, but in fact, the argument was, and is, that it was double hearsay and more. We don't know whether that happened or not. We have an ex-wife statement.
That's the argument you're making now?
I'm making that argument now.
Is that how you briefed it before this court?
I briefed it as improper non-statutory aggravation coming in, and allegations.
Not see a difference between, and I don't want to beat this, but the distinction between double hearsay, it was impermissibly allowed in, not because it was a collateral crime, but because there was no way to establish it actually occurred. Do you see that as
I see a distinction.
Okay.
I do see that there's two separate, distinct issues. The cases I've relied on from this court dealt with precisely these kinds of things. Unsubstantiated allegations of prior conduct coming in through the back door that amounted to non-statutory aggravating circumstances. I've cited at least 4 cases. Whether they got parsed out specifically in the trial court with a clean objection between the two different theories, their major argument was this stuff shouldn't be coming in, period. And in fact, at one point...
But you agree, or you probably might not, some stuff was appropriately rebuttal to what the expert for the defendant testified to.
Well, the defendant never testified.
The expert. I said the expert for the defendant.
It's interesting, though, because Dr. Pritchard was presenting all this stuff as foundation for why he had antisocial personality disorder, which wasn't in dispute. The other experts also agreed he had antisocial personality disorder. That wasn't a disputed issue at all. The focus, again, the two major problems were, again, bringing in sexually molesting children was irrelevant. And number two, perhaps we should have had a cleaner objection saying, well, they didn't prove it either, but it was apparent that it was based upon double hearsay at least. Moreover...
Was that contained in police records or expert witness records?
The record was, according to Dr. Pritchard, said, I read this in a police interview of the ex-wife. And she talked about other uncharged crimes, but this one kind of went beyond the pale because once you talk about sexually molesting children, which had not been an issue in this case before, that certainly is going to inflame the jury.
Well, then you get into, because you have an expert testifying based upon records rather than personal examination. So the question rises as to the extent that that type of witness under our evidence code, how far can they go within those kinds of records and documents that we're dealing with? That's what I was trying to understand.
I think, as I understand
the source of this.
As I understand the evidence code, is that experts are allowed to testify to opinions, are allowed to rely upon both admissible and non-admissible background information, but that doesn't make the non-admissible background information admissible.
No, I agree that. I totally
and I think
agree
that's what
with
happened
that.
here.
But the question is, to what extent can they rely upon information, and to what extent can the information be stated in a courtroom without placing the document in evidence?
That question wasn't precisely litigated below.
Yeah, well, that's what Justice Parente is saying, is that the objections weren't made so you could test all these different things.
The experts routinely review a lot of materials before they render their opinions, and they often summarize them, some of their background information. I think the question here went over the line because this was inadmissible evidence.
I know the state goes to this, but in this case I'm going to go to it first, which is, let's assume that particular bit of testimony shouldn't have come in. In terms of the aggravators in this case, you have the kidnapping, pecuniary gain, you've got the other murder that occurred. You have CCP, maybe not HAC, but even with that, you've got substantial aggravation. How would this be? Why would this not be harmless error if it was properly objected to? But if it wasn't properly objected to, how would this be considered even to be fundamental error, so that it deprived Mr. Hilton of a fair and reliable penalty phase? In other words, in the context of the aggravation in this case.
Why isn't it harmless?
Well, but that's if it was objected to. So if it's either why isn't it harmless, and if it's not objected to, how is it fundamental error?
It was. I think anytime you inject something like uncharged allegations of criminal conduct, particularly when you're talking about sexually molesting children, when it's not relevant to the case.
Well, what was the exact statement made? What did the experts say that the ex-wife had? Do you have the quote? I mean, I
have quoted part of it in the brief, but actually he went on about this allegation for a couple of pages in the record. He said that she indicated that her, in addition to the fraud things that she had talked about, that her 9-year-old daughter said that he touched me sexually, reported that to her according to her statement, and that she also learned later that he had also been sexually inappropriate and touched and involved with her son. So she testified to both, and in fact,
and that was in what? How many years? What year was that occurred?
As I recall, they were married. I think it may have been back in the 70s. I'd have to double check that.
And did the prosecutor in closing argument talk about that?
The prosecutor did not talk about the sexual offenses. The other matter that I'd like to bring up in just a moment, he did, but not about the sexual molestation allegations. She also, she confronted. She said she confronted Mr. Hilton about it, and he said he admitted to it, but he didn't see anything wrong with it, and those types of things all came out in front of the jury.
And this was in the context. She was talking to a police officer about what? Was she reporting the sexual conduct, or?
I am assuming that this was a police interview based upon all the background information they were gathering on Mr. Hilton. This was a very involved case both in Georgia and here, and I believe it was a Georgia Bureau of Investigation police agent that they were gathering information.
So it was a more recent. The police report was more contemporaneous, but the ex-wife was relating something that had happened
years earlier.
And was there any other substantiation that had occurred?
No. So, again, based on this court's cases, this is the kind of evidence that taints the penalty phase. It impacts the by injecting non-statutory aggravating circumstances into it. I mean, it's a defect that how do you parse out what kind of taint that may have had on the jurors?
Well, that would be under the harmless error
Right.
standard. If it's not objected to, then you got to go to the higher standard.
Well, that in light of what he actually did here, the kind of crime it was, the kidnapping, murder, the decapitation, admission that this wasn't the first time. In light of those facts, how could it possibly be prejudicial?
It's a structural problem. It's a structural problem in the fairness of the penalty phase. It's a due process question. When we're talking about imposing the ultimate penalty on an individual, this court has in the past held we're not going to allow this to happen. You've got to be more cautious in a penalty phase of a capital trial with this kind of information coming in. Again, I think with the Geralds, Perry, Hitchcock decisions. In fact, in a couple of those cases, the allegations were much less egregious than what we had here, and this court reversed nevertheless. It's a structural defect, and if we allow the horrendousness of the offense to control the fairness of the proceedings, then we're going to start bumping into some real constitutional problems vis-a-vis due process and the application of the death penalty. And I think therein lies a real problem.
We should, looking at the record, come to a conclusion that the defense approach was that this defendant was a straight, ordinary guy, law-abiding citizen, straight arrow kind of person until he was medicated, and that was the approach defense was taken. This kind of information, admissible through an expert witness, testifying with regard to his expert opinions, with regard to status of the defendant?
I don't think that it would be admissible through the testimony of the expert about stuff that he reviewed for purposes of rendering opinion. It may have been the subject matter of evidence that the prosecution may have wanted to try to prove in the proceedings, but there's no proof.
That goes back to the question of the type of objection that was what was presented to it, how it was preserved.
Yeah, the state made no effort to try to actually prove these things. This just came out.
The defendant didn't, the trial court, looking at his sentencing order, doesn't reference that at all.
He does not reference the sexual molestation issue. I see I'm about out of time, and I have briefed this issue. I would ask the court to look at it. There was also a question of indications. They had indications that Mr. Hilton may have been involved in making this horror movie where the subject matter was to release young women in the woods and hunt them down like prey. That was totally unfounded. I mean, they had when it first came up, and actually during the motion for mistrial, when it first came up during the testimony of a defense expert, he just mentioned that his employer said he'd been involved with making a movie, which he thought was sort of delusional that he'd actually been involved with making a movie. He was cross-examined on that question, but the prosecutor injected the content of the movie. The expert didn't know anything about the movie, but the prosecutor injected the content of the movie into the case through his questioning. Later on, Dr. Pritchard picked up on that, took it as a proven fact that he was involved with the movie, and said, look what happened. This crime, he brought it to fruition in real life, this movie. Well, the only evidence...
What did the defense do when the first witness talked about this movie?
There was no objection. And the reason was the witness knew nothing about the movie. It would have been nice to have had an objection, the content of the prosecutor's questions, but it was brought up again, and it was also referred back to in the motion for new trial because Dr. Pritchard brought it up. And Dr. Pritchard used it as if it was proven. And in fact, there was no proof. And the prosecutor, when asked, says, well, I don't really have a source for that because there was a one-page report that indicated it, but I don't have a source.
Did Dr. Pritchard get it from the testimony that had already come in, or was it a part of the documentary evidence that Dr. Pritchard reviewed? That's
not clear where he got it, whether he actually had the document, which we don't know what, it had no source mentioned, or whether he had heard it mentioned in the courtroom, but he had access to all the documents as well as that. And
We're down to about 2 minutes for rebuttal.
Yeah, let me save that time. I appreciate it.
May it please the Court, Meredith Carbula for the Appellee Attorney General's Office and the State of Florida. I think first, just touching on the first issue, Justice Quince, this notion of this admissibility of a statement, I started hunting in September. The statement Mr. Hilton made to an investigator from the Leon County Sheriff's Office during the course of taking his buccal swabs for DNA, and he also repeated it when he was being transported to from Georgia to Florida, and he said he started hunting in September. And as you said,
what does that mean?
Well, the trial judge found that when the objection was made, found that it did not imply that he had committed other crimes.
What does it mean?
Well, I think one reasonable interpretation of that is that he started hunting for prey in September, which is, of course, directly relevant if you take it that way. And as I say, I think I mentioned in my brief, we have to take this from the perspective of the jury hearing this who doesn't know about the Meredith Emerson case.
Except for then he says, like I told you before, when I saw you before, I said, I'd give you one for free. Nothing before September, okay? I mean, I'm not joking. So, coupled, what does that mean? What does that statement
Again,
mean?
it's fairly ambiguous, but one reasonable interpretation of that is that he premeditated this murder as early as September 2007. Which
what
would
is
make
I said I'd give you one for free?
I don't.
Doesn't that? I mean, to me, isn't the problem that you're not sure, and the jury's there thinking, well, there must be something else, another crime that is, I don't see where the probative value, I guess, outweighs some speculation as to what that means. I mean, it's...
Well, what the focus of the objection and the concern by the defendant, and even in the Hilton's initial brief, is I started hunting, not the I'll give you one for free. But in any event,
and how does that help the state's case? I started hunting, and like hunting for prey, like animals you're talking about?
Well, I think that given what we know about the case, I think that it's reasonable to conclude that he started hunting for Cheryl Dunlap, although he didn't know her name at that point. But it's relevant to premeditation, it's relevant to CCP, and of course in the guilt phase it's relevant to premeditation. In the guilt phase, in the penalty phase, it's relevant to CCP. I started hunting in September. The state was required to prove this murder was premeditated, and that was one element of the proof of premeditation, if you want to take it to mean that I started hunting for human prey in September 2007. So it's clearly admissible. The judge, even though he found it wasn't, the trial judge, very experienced trial judge, found, although it wasn't collateral crime evidence, he still did the 403 balancing test on that evidence, and he found that it was exceptionally probative to premeditation. And so when something is exceptionally relevant and probative, you have to have prejudice to the sky.
And nobody said anything about the one about I'd give you one for free, which doesn't seem to, the only thing in my mind it had to do with the other crime, but nobody made that argument?
That wasn't the focus of the argument. It was the I started hunting, which is also the focus, on appeal. Now, going to the second issue, of course, the issue is whether that's proper rebuttal or it's improper non-statutory aggravation. And
what about the argument, which is I agree that it's proper rebuttal to say, well, if you say Ritalin was what changed this person, you go back. But I'm most concerned about a backdoor of something that the ex-wife said happened in the 70s about a possible molestation, and allowing that to come in. Was that objection? Was that the way? Was it made that way?
It was objected to as collateral crime. The objection was collateral crime.
Okay, so not as to questioning whether it happened.
Not the sexual act. Not the sexual act.
Okay.
The issue of the movie, there was an issue of whether that had happened, and so let me maybe take the movie, the easier one first, perhaps. Dr. Wu, during his testimony,
referenced the movie.
This is the defense expert, Dr. Wu.
Okay.
And he testified about that it was his understanding that Mr. Tabor, who was Gary Hilton's boss for some 10 years before this murder, had said, apparently during the course of this investigation into the Meredith Emerson murder, that Hilton had said he had produced or he had helped make this movie Deadly Run. So that came in without objection. Dr. Wu said that his understanding is that Mr. Tabor said that Mr. Hilton admitted that he had made this movie. So at this point, there's no objection. And then Dr. Pritchard references it on rebuttal. And I think that's really a key distinction. We know the defendant's citations to Gerald's, Perry, Hitchcock. What the big difference in those cases are is all those non-statutory aggravation came out in cross-examination of the defendant's witnesses, not on rebuttal. I'm not pretending to say that the state could have called Dr. Pritchard up front in anticipatory rebuttal or could have presented this, in their case in chief at the penalty phase.
And what did the movie? So, the movie rebutted what?
Was the movie made? Do we know the movie was made? No. No. I don't think the issue was whether the movie was made. It was a question of whether Hilton participated in it. I don't think it was a dispute about whether this movie was made. I think the dispute was whether Hilton had a hand in suggesting the theme, which was hunting down women in the forest and killing them. That was the issue. But even though the experts, the defense experts,
was there a question as to whether that was the subject of a movie, that is women being, because to me, thinking about putting something together, that is really inflammatory on the issues of CCP, all of that you have now participated in making a movie about the exact thing that you then proceed to do. As a juror, I would find that very powerful if that's all linked together to him. So if there's questions as to whether it actually was made, you said it was made, but if he had anything to do with it, then that is awfully sketchy. So explain that a little bit more.
Well, I can't tell you it's made. It's not that it was made. It's not in the record, and I didn't go check my Netflix. So I can't tell you it was made. What I can tell you was that the real issue was whether Hilton participated in it to the point of perhaps suggesting the theme and helped produce the film. That was the issue. And when the issue of whether Hilton did that came up, Mr. Meggs had a report, and that's the report, I think, reasonable to infer that that's the one that Dr. Pritchard relied on, because he had a whole bunch of reports. That's what he relied on. And Mr. Meggs read this into the record. But what I think is really important, read this report into the record, and he up front admitted he didn't know the source of it, but it appeared that it was part of the investigation that the
I guess what I'm concerned about, and I'll look at Dr. Pritchard's testimony, it seems that, and you have this expert sitting through the whole penalty phase, listening to everything, and then it's as if he just took everything he possibly could come up with, little here, little there, and because the state belatedly did not get a chance to evaluate, that was the state's delay, and just kind of put everything in the kitchen sink in, and then it just got spatted out. And that's a concern. That's not really how we want expert opinions to be coming, with a little here, a little there. I mean, my goodness, I bet we could put together a picture of almost anybody if you went over their whole life and hearsay and this, and go, hey, this person was really, they said they're good, but they're really bad. Is that a concern I should have in this case?
No, Your Honor. And I think because if you actually look at Dr. Pritchard's testimony, it was very focused on the notion of that Mr. Hilton is a psychopath, he's antisocial, he doesn't have schizoaffective disorder. Because even though the defense experts did acknowledge that Mr. Hilton had shot his stepfather, had committed an act of arson, had been involved in an aggravated assault, threatened his boss, stole from people, cheated people, even though that was mentioned over the course of his life, Dr. Wu went so far as to testify that without Ritalin, Mr. Hilton wouldn't have committed this crime. Dr. Strauss described Mr. Hilton's involvement in minor scrapes throughout his life, but nothing of this magnitude.
Well, but you just said it came in, they admitted he had been involved in arson, in shooting his stepfather, that he had done all that. Now you then say, and in addition to that, he made a movie about the exact thing that he did. I mean, all of a sudden, now you take it like, this is this one sick person, and he molested his children. So you now go from things that are maybe explainable in a life, I mean, not in most people's lives, but, you know, things that are childhood things. Maybe he was protecting his mother, so the shooting doesn't seem so bad. And now you've got a total pervert. It transforms from that without there being the real basis that those things, in fact, either that he was involved in and they're accurate. That's my concern.
Well, I understand what you mean, Your Honor, but I think if you look at Dr. Pritchard's testimony in totality, what you see is him, rebutting the schizoaffective disorder, because their theory was schizoaffective disorder, organic personality disorder, and the Ritalin made me do it. But so,
don't you rebut it by just going, Ritalin is a common drug that does not cause somebody to start hunting a woman down and then doing what he did in this case? That is like an absurd argument from the pharmacological point of view that is not a known side effect of Ritalin. I mean, I just don't know that you rebut it by going, here's all the other stuff that he might have done, and we don't really know he did it or not, but that would really show that this guy has always been like this, not just the last 2 years.
Well, I don't know how you can tell a jury, because although this was mentioned by the defense experts, it was a mention with no detail, and the overall theme was that he had a major mental illness, schizoaffective disorder, and he had hit his head and been knocked unconscious when he was a child, and that Ritalin made him do it. And
now,
so
I don't understand. You said he was okay as a rebuttal. When Dr. Wu testified, then what you would say is, could the state say, isn't it true that he molested his daughter and son, or stepdaughter and stepson? Wouldn't that be, and that happened before Ritalin? Would that be a proper cross-examination? Because certainly, if it's proper in rebuttal, it would be proper in cross-examination.
Well, the problem with that is this court, I think, has distinguished, like in cases like Gerald's and Perry and Hitchcock, of asking. Now, of course, most of these were lay witnesses. I think arguably, yes, they could do that. But Dr. Wu was a PET scan. He was primarily the brain damage guy. And so, yes, perhaps he could have done this when he said, perhaps that question could have been asked when his opinion was without the Ritalin.
Who testified that the Ritalin was the trigger factor?
Dr. Strauss, Abby Strauss.
So could he have been cross-examined about?
Dr. Wu.
Didn't you know that he made a movie about this exact situation?
Arguably, yes. But
I thought you said that would be a question whether you could cross-examine about that unless it actually happened.
Well, there was no. The state offered evidence that Hilton had participated in making this movie, and they didn't contest the sexual abuse. They argued it was collateral crime evidence. But I think I think this court has cautioned in cases like Gerald's, Perry, and Hitchcock that cross-examination, you have to be careful not to bring in non-statutory that's more non-statutory aggravation when you bring it in that way. But the proper way, like this court said in Zach, was to bring it up in rebuttal. And as I say, the state's not saying that this could have been brought in during the state's case, but it is proper in rebuttal to rebut this overall theme of the defense is that this guy, although he's gotten into some minor scrapes, that he hasn't been violent or violated the law or violated the personal rights of others to a great extent until he went on Ritalin.
just because I'm very concerned about what you just said, I cannot imagine that we have gone to case law that says that the same bad act that is going to refute what an expert says cannot be properly subject to cross-examination, but it can come out in rebuttal. Now, clearly, if you're talking about the wife testifying on rebuttal that this happened, or you're talking about the person that made the movie coming in and saying, and he participated, I would agree. But if we're now talking about something coming in through the back door, it seems to me that the same reason you could put it in through a back door on, if you can, in that way, on if there's evidence in the record, would allow you to, with a request to the judge, to be able to cross-examine an expert on that. Do you think our case law is such that that it would not allow for that to happen?
No, but I think when you look at when a prosecutor makes a decision of when he's going to put something in his case into his case, he looks at case law, and this court has warned, albeit in a different context, about putting in something through the back door. You risk putting something in the back door if you bring it in the defense case. You don't, in accordance with this court's case in Zach, if you save it for rebuttal. And what we see with Dr. Pritchard is him, number one, setting forth the basis of his opinion for antisocial personality disorder. And I couldn't agree with Mr. Hilton more that the statute doesn't permit that. 9705 says that an expert need not explain what the basis for his opinion. It doesn't say he's prohibited from doing that. So when you look at Dr. Pritchard's explanation of why this is not schizoaffective disorder, this is antisocial personality disorder, coupled with the fact that the theme of the defense case was, and more strongly, I think, the defense case was Ritalin made me do it, then this evidence was proper to come in. And really the only thing we're fighting about is this involvement in the movie Deadly Run and the sex, which hasn't been contested that it happened. So because almost everything else came out through the defense experts. So the question is then if this court, and I would ask this court not to get there, but if this court does get to harmless error, it's clearly harmless beyond a reasonable doubt. The jury making a movie pales in comparison to the murder of Meredith Emerson, where he kidnapped a 24-year-old hiker off a mountain in Georgia, kept her for 3 days chained to the bottom of the seat, raped her because he thought she gave him too much trouble and he had to spend gas because she gave him the wrong PIN numbers. So it just pales in comparison to it. The prosecutor didn't even mention the sex. Mentioned in closing argument briefly a horror movie with no details whatsoever. Never argued that it should be considered as non-statutory aggravation. Never argued that it should be used to warrant the death penalty. And the trial judge, of course, never used it in his sentence. So given the strong aggravators in this case, including the prior murder of Meredith Emerson, it's clearly harmless beyond a reasonable doubt. If this court has no other questions, then the state would respectfully request that you affirm Mr. Hilton's conviction and sentence to death, by which the jury recommended 12-0, and that overall all the judges' rulings should be affirmed. Thank you.
Briefly, Dr. Pritchard's testimony clearly linked up the Deadly Run movie and Hilton. In his testimony, it was beyond the mere fact that there was no, number one, there was no indication in the movie Hilton was involved in making the movie. Pritchard nevertheless said he found, interestingly, his testimony and the words he used, indications that Hilton in 1995 was involved with
Let me ask you this about this movie. The movie information came out in Dr. Wu's testimony, who was a defense expert.
Just the title of the movie was the only thing he mentioned, because that was Pritchard's employer had mentioned. Yeah, he even talked about him making this movie.
And that was included as a part of Dr. Wu's report. I mean, the defense attorney knew that Dr. Wu had this information and this was going to come out.
Yeah, he did not have any information about the movie involvement. What he had was Hilton's employer's statement. And his employer, in talking about how Hilton's behaviors deteriorated, says, yeah, he even talked about having been involved in making this movie, Deadly Run. That was the only thing Wu knew, Dr. Wu knew. And it was
the defense didn't care that information came out.
I'm sorry?
The defense did not care that information came out at that point, and they never said this isn't relevant or anything to the
Well, they
witness.
didn't because in the context. Now, it would have been nice if we'd had an argument that the prosecutor's questioning about the movie of Dr. Wu, where he kind of related some of the context of the movie and the subject matter.
Right. So once he had talked about it, the prosecutor then asked him further questions about this movie, and so we have in the record,
Wu had no answers.
Without Dr. Pritchard, that this Deadly Run movie was made and somehow the defendant was involved in the making of that movie.
Well, there is no evidence that he was involved in making of the movie.
But it was said.
It was said.
Okay, and there was no objection to the fact that it was said that
about the name of the movie alone. And he came when Dr. Pritchard took the context of the movie, and he tied it all together and said, "Isn't it interesting? There's indications that he was involved in this movie, releasing these women in the woods to hunt them down, and now he's made it into fruition."
Why did Dr. Wu raise this issue anyway?
I don't know.
And he was the defense's expert, right?
He raised it because I think the employer thought, as did Dr. Wu, that it was sort of ludicrous that he thought he was involved in making a movie. So that was a perhaps indication of delusions. He backed off. He says, well, if he actually did, then he took back that portion of the testimony. But Dr. Wu didn't know anything about this movie. He didn't know anything about Hilton's and may or may not have been involved in it at all. Dr. Pritchard acted as if the movie had already been made and took it as a premise that Hilton had created the idea for it, and then he brought his idea to fruition in this crime. So he used it as a character attack, even though there was no proof he was actually involved in it.
You are now out of time.
Thank you.
Thank you for your argument. Next case is Rodriguez versus Miami-Dade County. Begin.
Good morning. Irvin Gonzalez on behalf of Rodriguez. I'm here with Barbara Silverman, my law partner. May it please the court. We're here today asking this court to reverse the 3rd District Court of Appeals on 2 different grounds. One, on the acceptance of jurisdiction for review of a case on certiorari. And second issue is that they, in essence, found that there was a sovereign immunity preventing the case from going forward in reversing the trial court's denial of a motion for summary judgment. The facts of the case are important, so I'll briefly go into some of the key points. This case involves a shooting of a civilian by a police officer. The civilian is Mr. Rodriguez, who owned a store in Miami-Dade County. On Valentine's Day, he received a call in the middle of the night that the burglar alarm had gone off. He drove over. He's a former Marine. He has a licensed and registered handgun. He drove over to his business and saw that there were individuals in his store. As he came out of his vehicle with his handgun, he was ambushed by a police officer.
Well, now, since you want to go in the facts, you're going the ambush issue, the video was before us. And do you want us to revisit the facts as to whether the police car came up at the same time? You know, what's the significance of the facts? If it's an emergency exception, then isn't that something that under Kaiser and its progeny should be subject to sovereign immunity, not lack of a duty of care, but a sovereign immunity where you don't get sued? You understand? Because you're saying, obviously, if a guy is going and he's trying to protect his business and police come and ambush him and shoot without reason, that's not even, I mean, that's probably a crime the police have committed. But doesn't the DVD, the video, sort of belie what you just said about the facts?
I believe not, especially when read in conjunction with the expert Manning's affidavit that clearly establishes numerous questions of fact on what really happened. The video does not tell the entire story, nor does it accurately convey. We can't hear when the first shots were fired. We don't know exactly what happened. But the crux of the case really is that the police officer failed to follow all of the procedures that are supposed to be followed for the use of deadly force.
So this so it would be then an operational decision.
Absolutely.
So once it's operational, your view would be under Roe, you do not address this as, well, certainly you don't address it as cert, but it shouldn't even be a category of non-final appealable order.
Correct. And I'm a little disjointed, but I don't want to make the error that I saw some of my colleagues make by not answering directly. The Keisner case and the emergency discretion exception does not apply in this case because it does not involve a situation where the police was thrust into an emergency.
Well, but the police here are responding to an alarm, a burglary in progress. I guess you could take the view that whenever they get an alarm about a burglary in progress, they ought to just kind of wait till the dust settles and then make sure nobody's there and then go see what happened. But that's not the way the police respond to calls about burglaries in progress. And your client has an affidavit that says he was shot from behind, essentially. I have a hard time seeing how that can be squared with what I think I'm seeing on the video, which seems to show that he turned around before and was facing the officer before he was shot, because there's no movement of his body that would indicate prior to then that he had suffered a gunshot wound. If you get shot in the back, you're going to, it seems to me, you'd see something. So what we have is the police going and respond. You know, he summoned them. He's got an alarm set up that apparently goes to the police and has them come there. And to say that they should not treat that as an emergency when they see all this activity, a man in the parking lot with a gun and all the other things going on around there, that for us to sit here and for a jury to second guess how they're dealing with such a situation seems to me to be highly problematic. Why am I wrong?
Your Honor, I'll address it. And you bring up very good points, but I have answers for all of them. And if I'm allowed to develop it, I will explain. Number one, the dispatcher did not call it an emergency. It was a 23. If you look at the affidavit of Michael Manning, which is on the record, roughly page 316, Michael Manning says it was the dispatch was a 23, non-emergency. For it to be an emergency call by the police department, it would have to be a 23 followed by a number 2 or a number 3. Number 2 or number 3 make it an emergency. So it was a 23 in Miami-Dade County. That is not an emergency. It's a burglary in progress, no hostages, it's contained. When the police officers get there, the testimony of the police officer himself.
Before you move to your second point, I guess you're going to make, anytime you're telling me, and the record indicates that if a burglary is called in, that alone is not an emergency.
Correct. It is not alone an emergency as reflected. as reflected by the exception set forth in Keisner, discussed by the 3rd District in Robles, discussed by this court also in the city of Pinellas versus Brown. Because for the exception to apply, the police officer must not be the cause of the emergency, and I'll explain why he is. Number 2, there must be the need to protect citizens, and the choices must be between damned if you do, damned if you don't, a choice of 2 evils. The crux of the plaintiff's case, which we're really not discussing and is important, is that the police officer failed to use his policies and procedures before using deadly force. Had he followed his procedures, that's where the discretion is, we never get here. But he disregarded recklessly all of his procedures. He was the first thing he's supposed to do is let the matter develop, observe, secure the area, call for backup, stay within his car.
This is a policy that have been established by the police department?
Yes, it is in the record.
For 23?
No, 23 is the dispatch call.
Okay.
The policy for using deadly force, which was set forth in the record by Officer Manning, the expert, and it's clearly undisputed in this record. Before deadly force must be used, you have to observe, contain, create a perimeter, contain, stay within your vehicle, look for a safe place not to be shot.
But if somebody points a gun at you, if a law enforcement officer is confronted by someone who points a gun at him, once he gets to that point, you're saying he never should have been in the parking lot.
No, Justice Kennedy, I'm not saying that. I'm saying he should not have chased him down like Rambo, running behind him in an open situation where the only chance he had when Mr. Rodriguez, the store owner, turned around was to shoot him. He thrust that situation upon himself.
So are you conceding that he didn't shoot him until he turned around?
Well, the record, according to Mr. Rodriguez, he was shot in the rear end, which spun him around.
I understand that.
Now, if you look
I've
at
seen the video too.
If you look at the video, it looks like the shots may have come around when Mr. Rodriguez turned around. Mr. Rodriguez did not know the police officer was there. There was no shout, police, drop the gun. The policies and procedures would have required to look for a safe place not to be shot, to shout the command, police, drop the gun, to stay within your vehicle, to create a perimeter. If any of these policies had been followed, that's where the choice is. This doesn't happen. So it wasn't a situation like in Keisner, like in...
Keisner was dicta in Keisner.
That's right.
Keisner
City of Pinellas versus Brown, or the 3rd District opinion in Robles, where you have... It's bad if you do something, it's bad if you don't. For example, in Robles, the 3rd District was correct. Here we had a hostage situation of children in a bus, a man with a bomb. They're going to blow up the kids in a bus. The sharpshooter shoots at the terrorist, hits him, some shrapnel damages a child's eye. Clearly, this is a choice of damned if you do, damned if you don't, a choice between 2 evils.
I want to go back. But we're here really, and I want to make sure, you want us to get to the second issue and say that there's questions of fact. I'm more concerned about the certified conflict, which is whether this should come up by cert.
I understand.
But you may want to continue with the things that you wanted to tell about why this wasn't an emergency. So if you want to do that first, and if you're not finished with the first part, I just want to...
I'll jump right back, I promise you. The issues are very clear. Had he followed policies and procedures, his choice was do I follow policy procedure 1 or 2 or 3, all accepted. That's not what happened here. It wasn't a choice among policy procedures. He chose ambush, what the expert called tombstone courage tactics, which is Rambo-style police. Not acceptable, not appropriate under the rules. It does not fall within the exception created by the court for emergency discretion. Now, certiorari...
On that topic.
Yes, Justice Polson.
The dispatch, you said, was not an emergency. When the police officer saw him, Mr. Rodriguez, in the parking lot with a gun, did it become an emergency then?
No, it's not an emergency until Mr. Rodriguez turned around. And Mr. Rodriguez wouldn't have turned around had he not been startled by the police officer who failed to follow the policies and procedures. If you're going to say that a burglary, like Justice Quince is suggesting, is in itself an emergency for colloquial purposes and not as the police define it.
It's difficult for me to see, though, where a crime is being committed. You have a call, and you see someone in the parking lot with a gun. That, to me, seems to create an emergency.
It means you have to follow policies and procedures. It means you have to follow the rules that are created for the safety of the public and yourself. The rules are there to protect the police and the public. By violating his own rule, he put himself at jeopardy and the public.
What was he supposed to do when he saw him in the parking lot with a gun?
He's supposed to call for backup. He's supposed to stay in his vehicle. He's supposed to look for a safe place within the building to find cover. He's supposed to say, drop the gun, police. He's supposed to take 5 or 6 separate steps that are outlined in the expert opinions affidavit, which he failed to do. He did the exact opposite of what he's trained to do in the academy and trained to do before using deadly force. And he cannot be rewarded by the use of the exception on discretionary emergencies under these circumstances. It's not what the court intended to do.
Okay, you can go ahead. Please address Justice Perry.
Of course. And the reason I address the second point first is because our position is that no matter what this court decides to do on the first issue, it doesn't affect us because of the material facts, and the third district should be reversed. But the third district erred because there was no certiorari jurisdiction. The elements of certiorari jurisdiction are: 1, there has to be a deviation from an essential requirement of law tantamount to manifest injustice. Number 2, that it prejudices the entire case. And number 3, that it cannot be specifically corrected by direct appeal. So they don't. The third district did not have cert review. This court in the Department of Education versus Roe specifically said that issues of the denial of the defense of sovereign immunity did not allow for interlocutory review, and that case came up on cert review initially. The First District Court of Appeals said it's not appropriately called for cert because it doesn't meet the requirements of cert review, so we're going to treat it as a motion for interlocutory review.
Okay, let me ask you this question. What if this case was that your allegations were solely on the basis that the police department in Miami-Dade County did not enact proper procedures as are used, say, in other police departments around the country for how you respond to a burglary?
It's discretionary.
So would that then, question is there, when it's discretion, that's still discretion on the, I thought that, you don't think that would be planning on the part of the police department, what policies they're going to put in place?
Yes, policy discretion, therefore immune from liability.
All right,
I agree
immune
with you.
from, now, if
I
that
wouldn't bring
were,
that lawsuit.
If that were the issue and you brought it and the judge denied summary judgment based on not a failure, a lack of a duty, but on the operational versus planning, would that be appropriate for cert?
Not unless the court changes the rules. This court has the power to change the rule, but the way the law is today, Roe specifically says that if you sue under a sovereign immunity because you do not sue the individual directly, there's no chilling effect on the individual.
But does Roe actually address cert? I realize the whole thing is confusing because it starts off in the lower court with a claim, petition for cert, and they kind of go back and forth. But when it gets to this court, don't we consider it as simply an issue of whether the non-final appeal rule should apply and be expanded, and we don't really specifically address cert in that context?
You're correct. Procedurally, it came before the court, first as cert through the First District. The First District treated it as an interlocutory appeal. This court reviewed it as an interlocutory appeal case. But the reasoning and analysis used by the court applies directly. And it's very simple. The court actually uses the language that there is no prejudice to a governmental entity to defend the lawsuit. The fact that they have to defend the lawsuit itself is not, in and of itself, prejudice that cannot be cured by direct appeal at the end of the case, and discarded that analysis, which is the exact basis that the Third District used to determine that there was an appropriate basis for certiorari. So they fly in the face of what Roe already held, what this court already held.
Let's look at what that reasoning, though. Now, I understand that when someone's personal liability is on the line, that concentrates the mind significantly. It is a distraction, and it's a consuming thing if people are subjected to personal liability. But if when a governmental entity is dragged into court and is forced to litigate a case for which they have immunity from suit, they are also subject to distractions. They've got to send their people to court. They've got to go through this whole process. And at the end of the day, if they win because they're immune, I don't know that their sovereign immunity has been respected the way it should be. And I think we may have given short shrift to the governmental interest in not being subjected to litigation that has no basis.
This court has the power to change the rule, to request the Florida Bar's Rules Committee to make the appropriate changes. Currently, that is not the law. If the court determines that it should be the law, then certainly you have the authority and the power to do so and may want to do so. But before doing that, you have to recognize what will happen. The appellate courts, who are already burdened by economic challenges, will have a number of new cases reviewing all denials of motions to dismiss and denials of motions for summary judgment on governmental immunity cases. That is a significant burden on the court, which this court recognized in the Roe decision as one of the reasons why it would not be an appropriate thing to allow cert for this issue. The second reason was the chilling effect on individuals, and this court did distinguish the impact that it would have in individuals, as in Tucker, that allowed for qualified immunity to be reviewed directly by interlocutory appeal, versus sovereign immunity cases where only the government agency or government itself is being sued. A major distinction this court made, along with the floodgates analysis that the court made. If this court decides to recede from that, to change that, it can. That's not currently the law. Currently, what was before the Third District Court of Appeal was Roe and Tucker. This case does not fall under either one, and therefore jurisdiction was inappropriate. Notwithstanding whether this court decides to make the procedural change or not, and it may be retroactive if it's procedural, this case still should be reversed because the Third District erred in acting as a super juror in deciding questions of fact that were clearly outlined by the expert's opinion, found by the trial court, and no matter what happens with point one, the case should be reversed on those issues.
On that issue, we've got this videotape, and it seems to be, at least arguably, in conflict with the affidavit, your client's affidavit. And let me give you a hypothetical. If we have video evidence and the authenticity of it is not in any way challenged, that simply cannot be reconciled with an affidavit in a summary judgment proceeding, and the court, as the U.S. Supreme Court has done, discount the affidavit in light of the video.
As questioned, yes, but it ignores the expert testimony and the policy and procedure manuals that were totally disregarded. That's a material part of the case that can't be ignored and it can't be disregarded. The expert testimony, the affidavit that can be found starting on page 313 of this record, relevant parts in 316, clearly established that none of the rules before using deadly force were followed, that the police officer acted recklessly, that he endangered his life and the life of Mr. Rodriguez inappropriately. And those are questions that are appropriate for the fact finder. So we request that this court reverse the Third District Court of Appeal and allow the case to go back for trial, and I will reserve whatever time I have left for rebuttal. Thank you.
Good afternoon. May it please the court. My name is Erica Zarin, and I'm here on behalf of the respondent in this case, Miami-Dade County. At issue here in this case is Miami-Dade County's sovereign immunity from suit for the actions of one of its police officers in what amounts to a 13-second confrontation where that police officer arrived on the scene of an in-progress burglary, saw a burglar, saw two potential suspects down the road, saw the plaintiff's vehicle cross his path and drive into the parking lot, park his car, emerge with a gun, and point it at the officer. And we would respectfully argue that those facts establish without question an emergency for which the county is entitled to immunity from suit.
If I looked at Keisner, it seems to me that what Mr. Gonzalez is arguing is that the policy and procedures were not followed, and therefore that what we are talking about here is not a discretionary planning level, but an operational decision. If we decide that's correct, even though it may be that you're right on the second part, which is that it was enough that a reasonable person would do what the police officer did. Do you agree that if it's operational, that it's not subject to, and never could be subject to cert review based on our prior case law?
I would agree that if there is an operational activity, then the conduct actually falls into the waiver, into the 768-28 waiver, for which there is no immunity from suit. However, I would like to respond to your question about Keisner. Keisner specifically says that it was a case where it was an operational activity. There was a traffic stop violation. But what it said was that the result that they reached would not be the same if the officers had been confronted with an emergency requiring swift action. And I think it's that word confronted which is so critical to your analysis.
See, but the problem I have about Keisner is that's really dicta. And even though there may be a separate policy for why there should be immunity because of, or less liability because of emergencies, I really get concerned about this thought of, and again, I'm not criticizing what the police officer did or not, but that there are across the country lots of police where police shoot, and there are investigations, there are lawsuits, and I never thought that the operational discretionary would apply. It's like the high-speed chase cases, that those may be cases where they're not de novo duty or they're not liable, but as to they're not the planning level sovereign immunity kinds of things that we talked about in commercial carrier. And I think we've kind of put the two together to say they're all separation of powers issue, when really maybe it's just there's an emergency exception that there should be a summary judgment as a matter of law. We're making that policy, but it doesn't really have to do with the waiver of sovereign immunity, like if we were criticizing the kind of policies the police had. Do you see that distinction? And that's why, and Keisner and also the other case, Pinellas Park, where they'd already been either litigated, they didn't come up as interlocutory cases.
Yes, well, there's two steps to it. First, you have to decide whether there is an operational or discretionary function. What Keisner and what City of Pinellas Park, those two cases are both saying, is that when a police officer is responding to a serious emergency, his or her actions within that time frame will be tantamount to an executive act, an executive discretionary act.
Can I ask? I mean, that almost defies common sense, for the reason that police officers, law enforcement, that's what they're for, is to become involved if there is a problem. And they're confronted with problems daily, hourly, minute by minute. And if we have a blanket rule that you cannot review the manner in which they respond to the circumstances that they face on an operational level, on the streets, engaging with the people, then we've gone back to, it seems to me, a total immunity for government operations. Why can't this be handled under a case like Scott versus Opelika, where are you familiar with that case?
I'm not, Your Honor.
Well, that's a case from Dade County where Officer Teppenpaugh from Opelika came upon, was summoned to an event, and there happened to be some gunfire exchange, and the guy had got shot and wanted to sue the officer in the city, and the 3rd District affirmed a sudden emergency instruction so that you evaluate the police activity from that sudden emergency, not of their own making, is what's required. But don't we get into just everything's immune if we only view this as whether it's discretionary or not? It's what they're doing on the streets in applying what policy's been established. Seems to me that we have just gone back to absolute immunity.
I think that it's the nature of the emergency. I think most cases that this court has considered, Keisner and City of Pinellas Park, you were all very clear that there was not an emergency, and so we will see if the officers who had the ability to take control of a situation, to exercise some control over their response, and have the ability to think through policy and what should be done from here on out. Those cases are distinguishable from the Robles case. And from, I would argue, there's a federal case called Smith v. City of Plantation, where police officers, and this was applying Florida law, of course, responded to a hostage situation, and they had 80 seconds in the home to try and take the situation under control. But because of the high-level nature of the emergency, when there was ultimately an explosion at the home, the officers were given the city was given the benefit of immunity in those circumstances. I think it's also important to remember that this is a case only about negligence.
If that was in federal court, was that a 1983 action?
No, it was. There was a 1983, but it was also interpreting a Florida law negligence case. And I say that because it's important to keep in mind what is and what is not at issue here. This is not a case where if the plaintiff had wanted to, he could have pursued claims and did at one point pursue claims for a 1983 violation and for battery, which is really what is potentially at issue here. But he voluntarily dropped those claims many years ago. So the principle of separation
if he could bring a 1983 action and a court, because 1983 can be brought in state court, correct?
Absolutely.
There's going to be a jury to evaluate those actions. Aren't we going back to this idea that somehow, in terms of what we were talking about, separation of powers, where the justice system is going to leave it alone, is not meant, in terms of, certainly for cert, to apply to every time that there's a claim that the police are responding to, quote, an emergency. And that is my concern with the third district's opinion, because the number of it gets appealed as cert, or the number of things that a court has to go through, appellate court, on a non-final order, creates, the record is different. You have to have the appendix. If we're going to say there should be police emergency claims should be raised on non-finals, then we should do that by rule. But I'm concerned about the vehicle of cert as being the vehicle that you try to ferret out those things. Do you see the difference there? And tell me why that's not a problem for the appellate courts.
In terms of the burden that it would put on
them.
Trying
to make all those judgments, like here he's saying it was a 23, not a 23-2. Here he's saying that the police didn't say stop police, which certainly distinguishes between you think you're the owner responding to a burglary and all of a sudden someone has a gun. You don't think they're police. You think they're the people that are trying to rob you. That's a big difference if he didn't ever say stop police. To me, how is that not something that is a factual case? And even if it is or isn't, that shouldn't be reviewed by the third district or any appellate court after a judge listening to the same thing says, no, there's factual disputes here.
Well, there's a bunch of questions in there. I'm going to try and answer the one involving sovereign immunity, because I think what's important here is if you accept that in Kaiser and City of Pinellas Park you established that there is an emergency exception, that gives the county sovereign immunity from suit. And there has never been a case that I've seen at this level, at the Supreme Court level, or besides Roe's, the suggestions in Roe. And keep in mind we have the Wallace case, where you just a few years ago said that sovereign immunity is immunity from suit. There's never been a case that has found any kind of immunity from suit to not cause irreparable harm if erroneously denied. As in, for example, Tucker talked about qualified immunity and the deprivation of that immunity causing potential irreparable harm if erroneously ruled on. The same thing with tribal immunity. You have immunity under the Neurological Injuries Compensation Plan. You have the Cedars Healthcare case talking about hospital licensing statutes. My point being is that once you find that sovereign immunity from suit applies, there is automatic irreparable harm, and that's what gets us to the courthouse doors through writ of cert. But I do want to correct some things that have been said about the record in terms of what actually happened.
Just before you leave the cert, really from an overall policy viewpoint, rather than have a mishmash of cases going on appeal, going on cert and all that, would it not be better that we would have a rule, and at one time we even passed a rule with regard to workers' comp immunity, to have an interlocutory appeal rule on all immunities?
It would certainly be, I think,
isn't
the
that
cleanest.
a more workable situation than the hit and miss of cert from those who say they're immune to get consistency in the law, it would seem to me.
I absolutely agree. It would be the simplest way. I wanted to cure one concern about the volume of cases. Although 768 is a limited waiver, because there are cases, discretionary function cases, my case, I would argue, that the waiver does not apply. When in practice, at least in the county, from what I've seen, the waiver applies to a large number of cases. A large number, meaning the average slips and falls, the average bus accidents. That's your volume of cases that the state has waived immunity from. So those cases would always have to go to trial because there is no immunity from suit for those cases.
Well, you get the same thing when you try to convert everything that police work involves into discretionary level, because a decision to operate a motor vehicle more rapidly than one should. I've made the decision. My discretion was I pushed the gas pedal a little harder. I mean, you can always say that there is discretion in how you behave.
But this court has been consistent in limiting that, I think.
No, I think really what it is that the point is talking about what does policy level discretion mean? To me, I've always operated under the basis that it's not the street level application of what a government. It's the city council. It's the at home the board of county commissioners. It's the public safety department rules that kind of thing. Not what happens out on the street, because I mean everybody makes a decision to do something. I mean, it's not intent, but you make a decision. So why doesn't this just bleed over so that we're doing absolute immunity for all government activities?
I think that would go too far, because you're right, most activities, even in the law enforcement context, are operational in nature. When you make the decision to pull someone over, you can decide not to, or you can decide to pull them over. That is discretionary.
And how you do it.
Once you do it, you have to do it with reasonable care.
Well, what about and then there's the high-speed chase situation, which I think we've allowed those cases to go forward. And I guess that to me, right now there's no volume because Roe is pretty clear. But once you say, well, if it's an emergency or if it's sort of this, maybe there's a mixture. Maybe Mr. Gonzalez said there was bad police, policy, and also there's operational level. And now we've got that mixed thing. And I mean, I would think that if we're talking about something which is clearly no factual disputes, but it was, again, how many police should have been sent out by the dispatchers. It was only one. There should have been two, but there's no policy about that. And what they say, there used to be, but there was a cutback. Those facts. You have then, those are clearly planning level, correct? How much? Okay. This just doesn't seem, and I want to go back to see what we said, Pinellas, in the same, that the emergency exception may come from another deference that's different from the other kinds of planning level. Do you agree with that?
It is. It certainly doesn't fit easily into the box of planning level. I have to concede that. Right. But what this court has done with those two cases is say that because we are so concerned that police respond to emergencies only, without fear that their conduct will be the subject of a trial, be it their own personal liability at the end of the day or their employer, because they want them to act without fear in 13 seconds, really in 3 seconds.
But you're saying they could have a 1983 action.
I said they could bring one. I would probably I would have qualified immunity for that. But, this is not the only kind of claim this is the only one at issue in this case. So I don't want it to seem as though, there would be no potential claim they could state. I think they could state a claim under federal law and perhaps get to
under
summary
the
judgment.
Emergency exception, there are limitations to that, because even under that they could not act flagrantly dangerous.
Absolutely, as you said in City of
So
Pinellas Park.
It's not an unlimited exception.
And I want to get absolutely, Your Honor. And what
but
I
you
want to
also then
to,
would turn back to overrule Wallace, because in that case, down in Ocala, had the sheriff not gone out, immunity.
It's true.
But once you become involved in the situation, it changes. So that's, I mean, it could very easily have said there, we're facing an individual who's in a coma. And within a matter of seconds, you're supposed to determine that, policy. And that's where I'm having concern with this, that the exception swallows the waiver of immunity is what we get into.
I think the consistent principle between like a case with the Undertaker doctrine, like in Wallace or in Pollock, where the dispatch called FHP said, we'll be there in a minute to deal with it, and then no one came, and you said there was no duty that attached. That's a duty analysis. But I think that the common principle is control. I think the fact that when you're dealing with a 13-second emergency or an 80-second emergency in a home, where there's gasoline everywhere, or a hijacking situation, and the police officers have no ability to wrap their hands around the situation and implement whatever policy applies, they have to be given some discretion to act within the means of what they've been trained to do. Which brings me to a point I'd really like to make. This affidavit that was introduced by the plaintiff below is an affidavit of an officer from City of Miami. And you asked the question, had this officer violated Miami-Dade policies? Well, that's not at all in the record. There's no Miami-Dade policy in the record that was violated or not violated. So that's a little bit, I think, of a red herring as far as an issue is concerned.
The affidavit did not make reference to the policies?
I don't believe so. I think it talked more I don't want to quote me, but I think it talked more generally about what you're supposed to do in these situations. But it's an irrelevant point anyway, because if anything, that might go to a duty analysis if a duty were to attach if there was owed a duty. Now, the duty question isn't before you because you very clearly in Wallace said there's no cert review for a question of duty. If this case does go forward, it's something we would revisit at the end of the case, which we're entitled to do. But let's just assume for a second that the duty did attach. Whether or not we complied with our policies, that's the only place it really has any relevance, whether or not the duties was breached through compliance with our policies or not. But I would argue from Keisner, I know that Justice Pariente, you said it's dicta, but it's important dicta in the sense that it talks about confronting an emergency, we're not arguing that an emergency was what we're saying that our officer did not create an emergency. He came to an emergency that had a few seconds had been ongoing.
But I thought but what he's saying is the emergency that we've talked about is where you think you're coming to something where, say, if he was told there are hostages in there. An emergency for the purpose, my goodness, in all these areas, the number of burglaries that occur every day, and God forbid we start to have innocent people being killed. It's not the same. Burglary is not a robbery. So he's saying that it wasn't called in as a emergency under the Miami Police Department. It was a burglar alarm. Sometimes they're false alarms, right? They come out to your house and they're false alarm. The police come with their weapons drawn, and then you're
That's exactly my point. This might have been an alarm call, but when they got to the corner, the two officers saw someone physically in the building. They saw a car down the road with two who ended up being affiliated with the burglar and served time for it, and the plaintiff with his gun.
Did they get the burglars, by the way?
They got the burglars. It was pretty easy. They were right there. But my point is, you're absolutely right. I'm not here on a case where you're just responding to, because you're right, maybe there is a different way. That's not an emergency necessarily. I'm here on a case where my officer shows up on a corner, and at that moment he says he sees within 3 seconds 4 potential suspects, and within 9 seconds he's facing the barrel of a gun. That's my case. If that's not an emergency, and that was the rhetorical questions in the third's opinion, for God's sakes, what is an emergency? This is exactly why we give discretion. That's where the separation of powers comes in. The judiciary has to give the executive in these kinds of engagements the ability to act without fear of liability. And for those reasons, I would ask that this court affirm the 3rd District in its entirety. Thank you.
Thank you very much. The affidavit of Manning, roughly record 319, paragraph 15, discusses the deadly force policy followed by Miami-Dade Police Department. And it even quotes it. And it includes what the standards are, and also states that all reasonable alternatives should be exhausted or be inappropriate under the circumstances before deadly force is used. That means all reasonable alternatives, which include the number of alternatives that I outlined prior, looking for creating a perimeter, asking for backup, observing, looking for a safe place, shouting out the command, police, drop the gun. None of these were followed by the police officer.
If under that policy, if an officer is confronted with a person who points a gun at him, does the officer before shooting have to tell him to drop the gun?
Well, no, not under that circumstance, because that's not what we have here.
But I think that is what we have. I understand you don't think the officer should have gone up there, but once he got up there, the plaintiff turned around, and it certainly appears obvious that he's pointing the gun at the officer.
Correct. The police officer should never have done that. It violated every rule, every discretionary rule that was created. He operationally violated it. Had he not violated his own rules, he would not have thrust himself into a dangerous situation where he could have hurt himself, and in this case shot the innocent owner of the shop. That's why we're here, precisely for that reason. He needs to follow and operate the rules. The policy can be set. How you operate in it, that is not protected under sovereign immunity. And to answer Justice Parenti on Pinellas versus Brown, this court said the following: this does not mean that state agents can escape liability if they themselves have created or substantially created to the emergency through their own negligent acts or failure to adhere to reasonable standards of public safety. To fall within the Keisner exception, the serious emergency must be one thrust upon the police by lawbreakers or other external forces that require them to choose between different risks posed to the public. In other words, no matter what the decision police officers make, someone or some group will be put at risk, and officers thus are left no option but to choose between two different evils. Here, he had numerous choices that did not include evil, following proper procedure. It wasn't a situation where Mr. Rodriguez was held hostage with a gun inside, and he's about to be shot, and the police says, I'm going to have to shoot, I might hit Mr. Rodriguez. He created the emergency that caused Mr. Rodriguez to be shot, and for those reasons, and reasons previously stated, we request that the Third District be reversed and that this court enter the appropriate order.
Thank you for your arguments. Court is adjourned.
You're watching the Florida Channel, a public service of the Florida Legislature, WFSU-TV, and Florida State University.